Доброго ранку. Доброго ранку, вельми шановні.
Good morning. Good morning, dear participants. My hello, good morning. It's 10 o'clock sharp by my watch, and I think we can start. I'm Suzanna Mnatsakanyan. I'm the Senior Project Officer of the Council of Europe project, promoting social human rights as a key factor of sustainable democracy in Ukraine. And jointly with my colleague, Anna Hristova, who is the manager of the Council of Europe project, Internal Displacement in Ukraine, Building Solutions, we will moderate this event today. This is an online webinar where we're going to discuss social rights protection of internally displaced persons and other vulnerable groups, the European Social Charter and other European standards, and administrative courts case law in Ukraine. I'd like to thank all the honorable participants, all the who have been invited for having agreed to join us today. I want to thank all the participants who really expressed their will to improve their knowledge of this subject area and join the active discussion we're going to have. You'll have the program of today's event. You can find it in chat. You can see that. And also we as moderators will also be saying who the floor goes to, and then we will tell you how much time you have for the general discussion. Please take into account that today we have interpretation both into English and French, and of course into Ukrainian, because we're going to have experts who speak some of them English, others French. So please choose the icon of the globe and choose the language that you want to listen to, or else you will hear the original. Please also make sure that all the participants of this event can put their questions in chat. That is called questions and answers, Q&A. You can ask your questions that everyone will be able to see, as well as the answers that everyone will be able to see. Moreover, if you have any questions that require a broader discussion, the moderator can suggest that we discuss them all together. In a separate chat that is called chat, you can ask any questions, including the ones related to technical issues, access to interpretation, any questions you may have about access. I think that that would be enough for me to speak about technical issues. If you still have them, please let me know. We already have 111 participants of this event, and I'm sure that we are all ready to start. First of all, I want to thank the Cassation Administrative Court within the Supreme Court for this initiative and for our active cooperation. And I also want to thank for the initiative, and I'll immediately give the floor over to Mikhailo Smokovich, Judge, President of the Cassation Administrative Court of the Supreme Court, Doctor of Law, in order to start this event. So your welcoming words, please. Good morning, dear participants of this webinar. Good morning, dear organizers of this event. I'm very happy to welcome you all at this webinar. I'm very happy to listen to you all and to see you all in this mode. Nothing we can do, the pandemic, that's why we communicate online. This subject is very relevant and interesting. It was yesterday or the day before that I read a publication where a deputy minister of justice said how nice it is for me to inform all the Ukrainian society that the European Court of Human Rights has rejected an applications of our IDPs. And I was sad to hear that, frankly. So this subject is very relevant for us, and we have to get back to those people. We have to face them and to do everything to protect them. And of course, guarantees for protection of fundamental rights and freedoms for any country that tries to develop its civil society and to build the social country based on the rule of law is a priority task for us. The Constitution of Ukraine says that our country is a social state, and that means primarily that we have a state priority in terms of providing social economic rights to its nationals, but the current economic situation in Ukraine and the fact that sometimes we have this balanced current system of social security, social protection, would not allow us to turn this declaration into reality. The basics of the system for social protection, social security, have come out of the legislation of Ukraine as well as of its international commitments. Ukraine is a participant to a number of basic international treaties in the area of human social rights, in particular the European Social Charter. And in this aspect, serious problems for us are still implementation of the international law provisions in the national law and application of the provisions ratified treaties as direct provisions. But even if, but if the solution of this problem would mean that Ukraine can turn to a European model for the development of social security and social protection, and therefore the best possible protection for people's social rights. Today, we see that the government is trying to improve the current system of social security and social protection that would include separate activities to provide protection to certain social groups, as well as a system of social services accessible for various socially vulnerable groups. Because the economic justification and efficiency of the social protection, social security system and its needs-oriented nature for the needs of the most vulnerable groups is some of the most important standards of a social state. And the level of accessibility to social services for the people is one of the indicators of the quality of life in any country. With an effective system of social security, the government can clearly evaluate its economic situation, the needs of its people, and distributes the budget and other resources to meet those needs in the best possible way. In that situation, that case, according to international standards, the main task of the social security system for this country should be softening the negative effect of the factors that emerge during all kinds of reforms, soften them for the most vulnerable groups of population as a result of the armed aggression of the Russian Federation in 2014, annexation of Crimea and the city of Sevastopol, and starting an international armed conflict in the east of Ukraine. The issue of guaranteeing and implementing constitutional rights to every citizen of Ukraine has become especially important. Ukraine and the Ukrainian people have faced the problem they had never faced before of internal displacement, where people have to leave their residences in the temporarily occupied territories of Ukraine, displacement, movement toward other regions of the country. And as a result, the Ukrainian legislators, the legal professionals, and the judiciary started facing the problem of providing the rights of the IDPs whose legal status is established by the law of Ukraine on the rights and freedoms of the IDPs. The case law of the Supreme Court as regards cases for the protection of the rights of people who have who have had to mm, move away from the areas are primarily related to rejection by the local authorities of registration of the IDPs or rejected assistance to those families. And in this category of cases in 2020, as of today, the Cassation Administrative Court has received 2,571 cases, of which 53 dealing with the IDPs. The cases about appealing decisions of the pension fund that rejected the award of the pensions to the IDPs or suspension of such awards. In this category in 2020, as of today, the Cassation Administrative Court has 2,718 pending cases, of which 48 are related to the IDPs, as well as implementation by the IDPs of their election rights, etc. We can also see that the election law has now taken a step vis-a-vis those persons has been changed dramatically, so people can vote at the place of their actual location, and now these people can also implement their passive as well as active election right. Let me know that in 2020, the Cassation Administrative Court has developed and published a review of its case law in terms of the internally displaced persons, and therefore the public at large, as well as the legal community, have received access to this very relevant case law on the protection of rights and freedoms of the internally displaced persons. Besides, the year 2020 became special because providing social and protecting social rights is taking place amid the current pandemic, the coronavirus infection. And the situation we have now will probably remain relevant next year as well. Since the beginning of the epidemic, more than 9 months have passed in Ukraine. We all can see what grave consequences the epidemic has brought about, as well as the measures to contain it. And the very first legal acts to counter the infection in Ukraine were adopted in early February of 2020. And in early March, the problems became quite dramatic in terms of protecting human rights by providing equal access to justice and enhancing legal possibilities and legal capacities of the representatives of socially vulnerable groups and territorial communities, which is the main task of the country, especially given the quarantine. Although today the crisis still continues, and it seems that we need to give all of our time and efforts to overcoming its consequences, but we still should be preparing Nadi right now for the moment when we leave the quarantine, and we need to assess the possible risks to identify the range of people engaged in overcoming the quarantine effects, distribute the chores. At the stage when we are to leave the quarantine, this would allow us to work effectively and in a coordinated way for all of the system so that the government can provide social protection for the most vulnerable groups of population against the effect of the pandemic and its related crisis. Clearly, to improve the system of legal support to the internally displaced persons and other vulnerable groups, we need to have knowledge, to share this knowledge and experience, to develop constructive ideas, to improve the current legislation, and develop new legal provisions that would not only be declarative, however, that would really be able to help us implement these rights. Moreover, I want to emphasize that the legal community should have a new approach to the importance of the human rights, such as the free choice of one's location, free movement, the property rights, housing rights, social and economic rights of the IDPs. The government is now taking a lot of efforts for the armed operations for the conflict, but it also needs to streamline the implementation of the social rights of all the groups of population. So today, this event is about all those problems. important event and this webinar. And of course, it means that this is kind of a methodological support and assistance for the judges that helps them to provide the rights of those persons better in a more dynamic way. We have to keep thinking about them all the time. I wish us all fruitful work, professional discussions, and although we are all busy people, but I'm going to stay with you till lunch break, and then I will have 2 more sessions, and then I will be back with you. Sorry for taking a bit too much time, but as the president of the Cassation Court, I think I have the right for it. Thank you very much. Thank you, Mr. President. Thank you, Mr. Smakovich, for setting the tone to this discussion. It's true that all the issues you have delineated are very important, the ones that need to be discussed, in terms of the best European practices. I hope that today we'll be able to discuss them all. Now allow me to give the floor to Mr. Volodymyr Mazurok, Vice President of the National School of Judges of Ukraine, resigned judge of the Supreme Court of Ukraine, honored lawyer of Ukraine. Mr. Mazurok. Thank you, Susanna, for giving me the floor. I would just like to ask you for technical support, because when I start my brief presentation, so you can tell me how I can share my presentation on the screen, because at the moment I don't have this possibility. I hope that the technicians have heard me. At the moment, I would like to welcome all the participants of this webinar on behalf of the National School of Judges of Ukraine. I want to thank the co-organizers, who are the Cassation Administrative Court within the Supreme Court, and the Council of Europe projects, internal displacement of Ukraine, developing sustainable solutions, as well as promoting social human rights as a key factor of sustainable democracy in Ukraine, that have organized this webinar. I would like to note, to follow up to what Mr. Smakovich said, that after Crimea was occupied and after the armed aggression of the Russian Federation started in the east of Ukraine, Ukraine has had very many displaced persons who had to go away from their permanent places of residence. And Mikhailo has already said that the courts started facing a very dramatic issue, how to protect the rights and freedoms of those people who had to move away. That's why, as the courts of different instances and different jurisdictions started receiving those cases, clearly the National School of Judges, on request of the judicial community, began developing special courses so that the judges could see the experience of how such cases can be resolved. I would like to briefly share with you the experience that the National School of Judges has had jointly with the projects of international technical support to provide fair adjudication. Please, can you put my presentation on the screen, because I don't have access to it, although we kind of discussed it already, and I think that we had this access before. Mr. Mazurok, they tell me that you can share your presentation on the screen. You can do it. Well, but the way I did that before, we cannot do that. Maybe you can tell me what I should press, how I can press. You have share screen button next between chat and recording, video recording. You have to have this button, share your screen. Well, at the moment, I cannot do that for some reason. It's not working. That's why I'd like to share my experience as regards internal displacement, and then perhaps we will send the presentation later, because somehow technical support has not been provided to me. So I will just speak now, and we will share the presentation later. In cooperation with the international projects of international support, since 2016, we the National School of Ukraine started cooperating with the Danish Council for Refugees. As a result, we developed courses for the judges, such as protection of the rights of the IDPs, protection of civil rights of the IDPs, protection of civil rights of the IDPs again, and for successful implementation of those courses, we piloted them in all the regional branches, and we had 2 trainers for the trainers training.
В рамках проекту Ради Європи посилення захисту прав людини.
Then, within the framework of the project on protecting the rights of IDPs, there was a visit to the Council of Europe on standards of Council of Europe on protecting the rights of IDPs. During the visit, the participants had an opportunity to look into the principles of decision-making in European institutions. Also, providing the platform to decide on the further steps in protecting the rights of IDPs in Ukraine in compliance with Council of Europe standards. In 2018, the National School of Judges of Ukraine cooperated with Council of Europe project on internal displacement in Ukraine, which became a continuation of the previous project of the Council of Europe on protecting human rights of IDPs in Ukraine. And in July 2019, with support of the project, the delegation of the judiciary, Ukrainian judiciary, the IDP judges, including went to Strasbourg. And during that visit, the issue of the ECHR and ECHR judgments enforcement, protection of IDP's rights in compliance with European Convention on Fundamental Rights was discussed. And on the meeting with Anna Kivska, the meeting with the judge had a discussion on the case law of ECHR. Also, there was a number of roundtables conducted to discuss relevant issues on IDPs. And the IDP judges' activities. The judges learned about ECHR case law in the countries that are working on the matter jointly with Council of Europe project on internal displacement in Ukraine. There were seminars in Odessa, Kyiv, and Dnipro, in which around 60 judges took part. Most of them work on the territories with many IDPs living, and some of the judges have a status of an IDP. The topics of the seminars were issues of internal displacement in Ukraine, European standards and national challenges, key problems of protecting IDPs' rights in trial, learning about help platform and remote courses, the practical aspects of help courses on IDPs. We discussed registration, enrolling in a course. Also, the materials of the Council of Europe were harmonized with Ukrainian legislation. There was a remote training course, a help course on internal displacement. It lasted for 60 days, and 58 judges successfully passed the training. Also, there was an international conference on IDPs and remedies that can be used by IDPs, which became a concluding event, a help event on IDPs for judges. 40 judges participated in it that went through the remote training course on internal displacement, overcoming gaps in legislation on the way to better legislation, which is also a matter of judicial practices in the context of IDPs. There was a training course on internal displacement and national materials. There were comments from trainers and participants. They also looked into responding to internal displacement, international practices, and national practices. On the 25th of February 2019, and I'm moving to the regional practices here. In Kharkiv, there was a national seminar for judges of administrative courts, international standards and practices in protecting IDPs' rights and state stateless persons. In October 2019, in Odessa, jointly with the NGO and jointly with the UN, there was a seminar for administrative court judges. There was a discussion of pension fund payments to IDPs and Ukrainian citizens in temporarily occupied territories. And regarding continuing cooperation with the international technical assistance projects, jointly with Council of Europe projects on internal displacement in Ukraine, in 2021-22, it is planned to develop an integrated training course. It's planned to expand the target audience to work on a number of issues regarding not only IDPs, but also other civilians that were affected by the conflict. And amongst the key objectives for the nearest 2 years is the introduction in 5 regions, the recommendations and mechanisms that were developed by the team of the project jointly with the grant givers in the recent years, and also further working on these training courses. So in a nutshell, this is our experience of the National School of Judges with regards to the development, piloting, and introducing training courses for judges and court staff. These are training courses that can provide fair trial, fair consideration in courts of the cases pertaining to rights and freedoms of IDPs. And the seminar today, which is organized for the judges of administrative courts, it can help provide the consideration of the cases in courts on rights and freedoms of the IDPs. So I wish all of the participants of the webinar all the best of success and good results. Thank you very much. Thank you, Volodymyr, for your presentation, for sharing about productive cooperation with the Council of Europe and the training courses that we already developed jointly with the National School of Judges of Ukraine. I am happy to share that at the end of the webinar, we'll be presenting another training program that is being developed jointly, a program for judges on European Social Charter and the application of European Committee of Social Rights Practices, but this will be a bit later. Thank you very much for your presentation. And we already mentioned European Social Charter, and we briefly touched upon the practices of European Committee of Social Rights. It's my honor to give the floor to Mr. Giuseppe Palmisano, President of the European Committee of Social Rights, and he'll give his introductory remarks. The floor is yours.
Thank you, Susanna, and good morning, everybody. Ladies and gentlemen, remote participants and viewers, first of all, I would like to thank you for inviting me to the opening session of this webinar, giving me the opportunity to offer a little contribution to your work on the implementation of European Social Charter and the protection of social rights in Ukraine, concerning in particular today the protection of internally displaced persons and vulnerable groups. It is especially valuable to have this virtual meeting with Ukrainian judges, as the judiciary has the constitutional obligation to protect rights and freedoms of people, including social and economic rights. Human rights, whether civil, political, economic, social, or cultural, are indivisible and interdependent. Social and economic rights are also enabling elements for the enjoyment of civil and political rights. These are core European values enshrined in a number of formal commitments undertaken by the Council of Europe member states, including Ukraine. Respect for and the promotion of social rights is essential in attaining sustainable democracy in Ukraine. And the Social Charter is at the European level the fundamental point of reference for every state like Ukraine, which is willing to effectively realize social justice and sustainable democracy. In fact, Ukraine ratified the revised European Social Charter on December 2006, accepting 76 out of its 98 paragraphs. But unfortunately, it has not yet ratified the additional protocol providing for a system of collective complaints. Let me add that today, more than ever, reinforcing the protection of social rights should really be a priority for every European state. Since 2008, the economic crisis had an extremely negative impact on the most vulnerable persons. The measures adopted by states to cope with such crises, in particular the so-called austerity measures, also disproportionately affected those who are most vulnerable, the poor, the elderly, the sick. And traditional and consolidated high standards in the protection of social rights and some basic features of the welfare state, which are essential for the enjoyment of such rights, and of which European states should be proud, have been indeed put in danger. Increasing poverty and unemployment rate, in particular youth unemployment, social and economic inequalities, lack or shortcomings in migrant integration, job insecurity for many categories of employees, regressive changes in social security schemes and benefits, cuts in public health care systems, and increase in the cost of health care. These are, and they already were before COVID-19, among the most worrying signals about the state of social rights in Europe. And now we have a pandemic crisis to deal with. In such a situation, it becomes even more important to have an effective mechanism for the protection of social human rights. In fact, social rights rules enshrined in international instruments and incorporated into national legal system via laws and regulations become both collective and individual rights. A person may request the implementation of these rights from the state, as well as protect his or her rights in the court. In this sense, social and economic rights are not as dissimilar from civil and political rights as it was thought, in that all rights require interpretation to understand how they apply in specific contexts, and they may all require both negative and positive measures by states. Moreover, in the Ukrainian context, we can clearly see how the adjudication of social and economic rights can be interconnected with the civil and political rights. I'm referring here to the European Court of Human Rights judgments on Burmich and others, and Zofner even of group of cases, which concern non-enforcement or delayed enforcement of domestic judicial decisions in Ukraine. They relate inter alia to the effective delivery of social services, benefits, and particular social payments. Dear colleagues, if we speak about and try to identify the role of a state in securing social and economic rights across Europe, I would just say that such role already emerges from the provisions of European Social Charter, as well as from the conclusions, decisions, and findings of the European Committee of Social Rights. The European Committee of Social Rights is the body mandated to interpret the rights provided under the European Social Charter. It develops its interpretation based on the international legal principles by looking at the object and purpose of the Charter and adopting also a dynamic approach to the Charter intended as a living instrument, which is able to address current problems. And as you know, the respect of the Charter is monitored by the European Committee of Social Rights through the reporting procedure and the collective complaints procedure. In this regard, let me recall that insofar as they refer to binding legal provisions and are adopted by a monitoring body established by the Charter and the relevant protocols, decisions and conclusions of the European Committee of Social Rights must be respected by the states concerned. Even if they are not directly enforceable in the domestic legal systems, they set out the law and can provide the basis for positive developments in social rights through legislation and case law at national level. The decisions and conclusions of the European Committee of Social Rights are of utmost importance for the domestic courts while deciding on social rights cases, including employment-related rights, prohibition of discrimination, rights of children, people with disabilities, older persons, migrants, protection of health, social and medical assistance, right to protection against poverty, and right to housing, which mostly lay within the competence of the administrative courts in Ukraine. So, I encourage the experts here today to have an in-depth discussion on the application of the Charter provisions and the European Committee of Social Rights case law by the Ukrainian national courts and judges, as well as to consult the UDoc page for the case law with regard to specific issues they are dealing with. The European Committee of Social Rights case law is a practical and valuable tool to be used by the national courts when considering cases on social and economic rights. The conclusions of the European Committee of Social Rights can be directly used in the court's judgments. Moreover, the digest of a case law of the committee can be used for the interpretation of the social rights provided under the Charter. And I would add that we see today that in the nearest future, the issues of access to health care and non-discriminatory approach in the provision of a medical assistance, sorting of patients, might become a new trend in complaints lodged before the national courts across Europe. These issues, among other things, will be addressed by the European Committee of Social Rights in its future conclusions. Dear colleagues, allow me to stop here and let me also apologize in advance for not being able to attend the rest of the seminar. In fact, in a few minutes, I have an exchange of views with the Committee of Ministers of the Council of Europe. But I'm sure that your event will help to better understand the system of European Social Charter and the Committee's case law and enhance their application by the Ukrainian administrative courts. I thank you for the attention and wish you fruitful discussion. Thank you.
Щиро дякуємо, пане Джузеппе, за цей дуже
Thank you, Giuseppe, for this very important presentation. We really hope that our webinar today and our cooperation overall with the Cassation Administrative Court within the Supreme Court and the National School of Judges will help improve the practices of application of both the European Social Charter and the case law of European Committee of Social Rights by Ukrainian national courts. And I'm hoping that this will happen in the near future. Thank you very much once again for joining us despite your busy schedule. As I've already mentioned, our event today is organized by two projects by the Council of Europe, implemented within the Council of Europe Action Plan for Ukraine. And it is very important for us to see the synergy between Council of Europe projects and this very important long-standing cooperation with our esteemed partners. And for concluded introductory remarks, I would like to give the floor to Olena Litvinenko, the acting head of Council of Europe office in Ukraine. Thank you, Susanna. Thank you very much. Greetings, everyone, dear participants of our event. On behalf of Council of Europe office, to recap the introductory session of the webinar, first of all, I would like to thank our national partners, the Cassation Administrative Court, Supreme Court, represented by Mr. Smokovich, the President, the National School of Judges, represented by Vice Rector Mr. Volodymyr Mazurok, for their productive cooperation in implementation of Council of Europe Action Plan for Ukraine, and for their initiative, support, and organizing of event and participation in this relevant event. It's such a pleasure to see that we had Mr. Giuseppe Parmisano, President of the European Committee of Social Rights, with us, and the committee looks into the provisions of the European Social Charter and their observance in Council of Europe member states, protecting social rights and vulnerable groups of people. And through the synergy of projects, the development of human rights as a key factor of sustainable democracy in Ukraine and internal displacement in Ukraine, drafting of long-standing solutions. The event brought together, which is a great pleasure for us, for the Council of Europe. They brought the renowned experts of the national, the domestic level, practitioners to discuss protecting social rights of internally displaced people and other vulnerable groups of people, compliant to international standards and practices that exist in the Council of Europe members. The national courts, of course, play a crucial role in protecting rights and freedoms of people, including based on the international standards that will be discussed today. The European Convention on Human Rights, ECHR case law. However, in terms of protecting social rights, the European Social Charter is very important, which focuses heavily on social economic rights, and the conclusions of European Committee on Social Rights, which was represented today by our esteemed Mr. Palmisano.
Unlike the mechanism of the European Convention, where individual complaints mechanism works very well and people have access to the European Court, application of the provisions of the European Social Charter requires certain advocacy, participation of the civil society, consolidation of efforts of all the stakeholders, as well as practical knowledge of the Social Charter mechanisms. And today's webinar makes its contribution so we can disseminate this information about the international standards of the Council of Europe, the European Social Charter, as well as the best practices in terms of internal displacement, in terms of social protection of the vulnerable population that we believe Ukraine has as well. I think that this webinar is an important point for the project dealing with internal displacement, because its current stage is the final stage, and today the project team will have a wonderful opportunity to present the results of the project. As of the 1st of January, a new stage will start of the project that will last till the end of 2022, which allows us to plan support by the Council of Europe in the area of internal displacement and a long-term prospect. And of course, that would include such issues as social protection of the rights. And the project that helps implementation by Ukraine of the social charter and improvement of the rights of the vulnerable groups will definitely continue next year. And today's event allows us to take into account all the current challenges we're facing today as regards protection of the social rights and the future work of the project, and also inform you about the current activities of the project that have been continuing, and the training program that will deal with European Social Charter that Susanna has already mentioned. And I also hope that our today's discussion should be very interesting and useful for the judges in terms of administrative trials, for the lawyers, for the human rights defenders, researchers, and will help us strengthen the system of protection in line with the European standards, the best practices and provisions of the European Social Charter, the European Convention of Human Rights. Thank you for your attention, and I wish you all very interesting discussions. Thank you. Thank you very much, Olena, for summing up those opening remarks and for having said the most important thing, that this event, in fact, is to help judges to better apply those standards that some may not know yet, in particular the European Social Charter, the opinions of the European Committee of Social Rights, and to achieve the main goal, to provide better protection to social rights to the vulnerable groups of population. Let's hope that this webinar will help us do that. Allow me to thank all those who have joined this first part of our event, Mr. Smakovich, Mr. Mazurok, Mr. Palmisano, Ms. Litvinenko. Thank you very much for your words, for your interventions. They are inspiring and they have set the tone to our today's work. I hope that all the subjects you have covered will be discussed and we will reach our objective. Thank you very much. Allow me to proceed to the first main session of this webinar, which is going to be about the international standards and best practices in the field of internal displacement and protection of social rights of the vulnerable groups. It's very important for us so we can share our experience of the Council of Europe member states and tell you a little bit more about the Council of Europe standards and leave some time so we can discuss the application of those standards in Ukraine and the problems that Ukraine may face and what can be done so that the European practice can be used more often and in a better way. We have invited our international and national experts, and we will start with a general review of the social rights guaranteed by the European Social Charter, revised and case law of the European Committee of Social Rights, and its implementation at the national level, in particular by certain member nations of the Council of Europe. And we're going to hear about that from Ms. Carmen Salcedo Beltran, International Consultant of the Council of Europe project promoting social human rights as a key factor of sustainable democracy in Ukraine. She's a professor of labor law and social security at the University of Valencia, Spain. That's why she will emphasize more the practical approaches of Spain as regards the use of the case law of the European Committee of Social Rights and the European Social Charter in general. One more technical announcement for those who understand both English and Ukrainian, but Carmen will speak French. That's why please choose the language of interpretation that you need to, either English or Ukrainian. Thank you very much. Carmen, the floor is yours. You have 40 minutes.
Thanks a lot. I hope everything works well and you can hear me. Thanks. Hello, everyone. First of all, I would like to thank those responsible for the organization and for inviting me to participate in this interesting webinar. I'm very honored to participate with the authorities, the experts, and the international consultants of the Council of Europe and the European Social Charter, as well as the President of European Committee on Social Rights, and what's very important, the judges and the lawyers. Besides, I would also would like to apologize for presenting in French. I would also like to express my gratitude to the service of the Council of Europe that I have the means and so that it is possible. Precisely, all work to implement the European Social Charter, as well as the case law of the committee in the latest years, that were dedicated to my country's dedicated to. On the one hand, it was the application of European Social Charter for the internal jurisdiction. On the other hand, it was the ratification of the revised version of the Social Charter and the protocol of collective complaints. The results of the former started to be visible starting from 2013 in social justice order. Starting from that year, European Social Charter and authentic interpretation of the European Committee of Social Rights about the decisions and the conclusions became the most important instruments and the most efficient instruments to guarantee social rights in Spain. without any doubt. We can affirm that my country now works among the countries, the most advanced countries in the field of first and second court instances concerning the implementation of the European Social Charter. As for the second challenge, starting from the 10th of November 2020, the government of Spain started a legislative procedure, an urgent one, to authorize the ratification of the revised version of the Charter. As for the protocol, the agreement of the Council of Ministers informs about the ratification of collective complaints as well, but now it contradicts in the fact that if its acceptance is going to be in the specific declaration of the fourth part, Article D of the European Social Charter in the reviewed form, or it's going to be separate. Obviously, starting from the date, we work all the time with the NGOs, some trade unions, and social organizations, so that the first way is chosen. I would like to start my speech by stressing that it is dedicated to the main actors of the implementation of the Charter, namely the national judges. They are the most responsible actors to overcome this challenge. All the public institutions of the member states have to work with the have to adhere to the norms that the state has accepted. Their ratification has this consequence. However, in the contrary case, the judicial order works for their adherence and has to realize the social rights that the treaty guarantee to the population. The challenge as for the implementation of the Charter has a specific particular field. This is really important for the social groups and the complaints after the violations of the social constitution of Europe. This obligation has to be interpreted according to the progress which was made by the national institutions that are to monitor the adherence of the judicial order, including the European Treaty of Social Rights and the European Pact of the Social Democracy. In other words, the essential direction in the social dimension of Europe. I have to stress that this progress in the field of social rights, the constitutionality, and the social justice. I do that to reaffirm the value of the Charter and to regret that normally this implementation is put under doubts, is rejected, is removed, or receives negative feedback. This is explained by a reductionist and obsolete view of the efficacy of this international source. I would also like to stress on the efficacy term. This is an opportunity to advance in the implementation, which is wider than the justification. However, it only concerns the courts and the tribunals. And that is why I would like to affirm and I'm going to repeat this affirmation in the end of my speech, when I demonstrate that the only thing which is necessary to realize the implementation of European Social Charter and the justice of the European Committee of the Social Rights is to have the willingness to do so. European Social Charter is an instrument which guarantees efficient social rights. The content and the terms of the treaty are radical and firm. As well, the authentic interpretation of the monitoring mechanism, which is the intermediary for the decisions about the welfare and the conclusions, is restrictive. Both of them became instruments which are the most important to guarantee social rights. After this introduction, to explain the general view of the implementation of social rights guaranteed by European Social Charter on the national level, I mean the revised version, as well as the case law of the European Committee of the Social Rights, I divided my speech into three parts. The first part is going to describe some base notions as for the implementation to actually work with the obstacles which normally all the professionals face. I'm sure that you know most of them. But if we discuss the social charter, we have to repeat those, to insist, reaffirm, and remember, especially for the states and for the government authorities, the obligations that they take up on the day when they have signed the charter. After these general lines, I'm going to show you in the second part the panorama of the implementation of the Charter in some European countries. In this way, I'm going to reveal some basic notions when they are not adhered to when the treaty is applied. This can be a conclusion about non-conformity or a decision about the welfare. Even though there are some common oppositionary elements, I'm going to describe the great progress of some countries after the modifications of the work and the measures of governments because of the economic crisis. They are counter to the international engagements, and more ordinary judges state the inconventionality and actually cancel the legislative acts. Using some examples, I'm going to show that the implementation is totally realistic. The third part is going to explain the example of Spain. The reason to analyze this country in particular is in the course of progress which we have reached since 2013. Presently, this state is one of the most advanced in the field of efficient implementation of the Charter. It was very hard to achieve this goal, especially if we compare it with most of the European countries. Why so? Because this country did not ratify the revised version as well as the protocol about collective complaints. The national judges, even if the reality in Spain is very bad, inadmissible, inexcusable, and incoherent, still applied the Charter using the case law and the judicial mechanisms of the two control mechanisms. It's the reporting system and the procedure of collective complaints. Moreover, I would also like to tell you that we can affirm that the last 4 months have been especially efficient. Last July, 3 verdicts were applied to interpret 2 court decisions based on the 24th article of European Social Charter. So this is actually complaints 106 of the Finnish Society of Social Rights versus Finland, and Confederazione Generale Italiana del Lavoro versus Italy. I would like to stress that the 24th article of the European Social Charter in its revised form has a provision which is not a part of Spanish legislation. The national judges used synergy with the convention 158 of the World International Labour Organization. They stressed on the convergence of the 2 texts to international text to complete the text of International Labour Organization and to incorporate Article 24 and also the interpretation of the committee on that topic. This is a surprising situation, even unbelievable, but still realistic. Therefore, we have a question to find out how this success was reached. And I'm going to answer this question a bit later. After this introduction, the first part is going to be about some basic fundamental notions about the implementation of the Charter. I have to remind them, I have to insist on them and reaffirm them to face the obstacles that all legal professionals face sooner or later. If we hush it up and if we reject them, if the case practice of the committee, they can be explained on one key point. It's just the lack of knowledge. All the difficulties on that topic come together towards ignorance or bad knowledge, insufficient knowledge. I'm going to illustrate them a bit later. Unfortunately, it is very easy to find the example. I'm also going to talk about academic institutions, the universities, about the situation that they actually do not teach the Charter. The European law frequently only considers the law of the European Union. As for the Council of Europe, there only exists the European Convention of Human Rights. So instead of recognizing the deficit, they simply hide it, and the situation lasts, and the mistakes only are disseminated. And this reality has direct effect on the implementation. So this lack of knowledge is evident in 3 fields. First of all, this concerns the European Social Charter. In particular, there is confusion between the law of the European Union and the Social Charter. Just as well, the ratified versions of the Charter. In my country, this is a very widespread practice. Sometimes the authorities also use both versions to reach a conviction verdict. The lack of recognition of the European Social Charter in comparison with the European Union law and the European Convention of Human Rights, the confusion between the principles of the first part and the obligations and the rights of the second part, which counter each other for all public institutions which have state significance. The provisions of the treaty, they are very firm on this topic. Allow me to highlight them. The first part notes its program condition, but the second part distinguishes the engagement of the states to be considered tied by the obligations as a result of the following articles. The articles B and C of the Charter state that the states accept their legal obligations. Same, Article A remarks a different condition of the first part and the second part. Just as well, the European Committee of the Social Rights, in most of decisions, for example, the complaint number 19999, I would like to stress also on the topic which is connected to a contradictory effect, a direct vertical and horizontal effect between individuals, as they say. This means the responsibility of the state to adopt the norm which does not respect the ratified provisions. So, European Social Charter is a limiting international treaty. The fact that violation of the Charter doesn't have any sanctions behind it on the international plane still doesn't put under doubt this information. Secondly, one of the topics which is one of the most debatable is the European Committee of the Social Rights. The constant silence with this monitoring mechanism has the following implications. This is the non-recognition of the European Committee of Social Rights due to its non-binding character. Just as well as for its authority, which is weakened by the Council of Ministers in intervention in the monitoring process. I would like to stress on that reason, which ignores the value of the European Committee of Social Rights due to this intervention, by the very fact of it. In my opinion, it is one of the weakest, starting from the moment when the decrees of the European Court of Human Rights are transmitted to the Committee of Ministers, which monitors their execution. The same task does not doubt the decrees of the European Court. So we have to differentiate the field of the exclusive decision of the European Committee and the execution. They reserve the doubts about the functioning of the procedure of collective complaints, in particular the percentage which has risen among the complaints declared, and they state that the committee has received, and also extensive interpretations of the committee of these provisions. And of course, if this organization is doubted, even more there is the limiting effect of the conclusions and the decisions. In this way, the judges and governments don't feel obliged to follow the interpretations of the European Committee of the Social Rights. I have to remind you that in ratifying the Charter, the states accept the competence of its controlling institution. The states are also obliged to respect these decisions. So this is the legal status of the committee. Besides, being a sovereign body, an exclusive one, which is authorized on the international field to control the conformity of the law and the practices of member states to the Charter, its interpretation has to be considered authentic. This presentation actually is in conformity with the text of the Charter, which has to be read in the light of committee case practice and the main interpretation. It is necessary to reinforce the knowledge and the taking into account of the case law of the European Committee of the Social Rights, as well as the terms of the treaty, so that they are consistent with this case law. Thirdly and finally, obviously, the objections and the lacks of the two previous paragraphs now put the treaty and the case law in this system of legal sources and their rules of interpretation on the internal scale. The treaty does not apply and also does not confuse the control of constitutionality and control of conventionality, which is key to implement it all well. Frequently, the judges associate this implementation of the Charter with the confrontation of the jurisprudence of constitutional courts. For example, if they precisely stated the constitutionality of the norm, which does not adhere to the Charter. This is a mistake. We have to differentiate the control of constitutionality from the control of conventionality. Some illustrations show the bad knowledge of this and also show in a comfortable position. First of all, on the website of the Defender of Human Rights Organization in Spain, after you click on the mention of Council of Europe, there is a link of the European Council of the EU. Secondly, 20 days ago, website of the Council of Ministers in Spain communicated the news about the ratification of Social Charter in its revised form and put it as a Treaty of European Council. Last year, the same piece of news was put under the Charter of European Union. And thirdly, a recent decree of the Supreme Court in Spain as of May 2020 mentioned the European Committee of Social Rights and the Committee of Independent Experts. So it is a court which went to two monitoring mechanisms of the Charter at the same time. These mistakes can be corrected, and this is going to be a truly pedagogical task to tell apart the Charter and the case law of the committee. This is really indispensable for the judicial field, the lawyers, the NGOs, and the public institutions in general. In particular, on three main points. The limiting effect of the second part of the treaty. Also, the case law of European Committee of the Social Rights, the conclusions, as, for example, the authentic interpretation, the hierarchy between the international right, including the social charter, and the national law. The absence of confrontation and conflict between the sources of law if the implementation of the Charter is going to be realized. Here I mean the application of standard of protection, which is the highest, without canceling out the others. The control of conventionality and the main difference between it and the control of constitutionality, with the aim to show that there is no conflict between the decision or decree of the lower instance court and the case law of the constitutional court. Also, the lack of hierarchy between the law of the European Union and the law of the Council of Europe in the whole set of internal legislation. As for the second part, in general, the implementation of the social charter shows the problems that I have already described to you. They include the non-recognition, the arguments that question its value, and even more the European Committee. But I have to stress that there is a perceptible development in the last years, which passes into the opening of the Charter and the jurisprudence of the Committee. The national judges start to change their attitude. This progress is different. I'm going to illustrate it when I finish with the examples from my country. I believe that now the positive willingness of judges of the first and the second instance courts in Spain, and also their resistance, need to be examined and some time should be dedicated to that topic. The country which is in the end on the legislative level, but still in the avant-garde of the implementation of the Charter and the case law of the Committee. As for Turkey, the Constitutional Court and the Cassation Court constantly refer to the revised social charter, especially in the field of trade union rights and the dignity to reinforce their arguments. We can talk about direct application of the Charter, even though in a superficial manner. As for Austria, programmatic references, though general, during the legislative modifications for their support. As for Germany, the courts are favorable towards international law. They interpret the national law in a more favorable way, though. They take the right to strike, for example, from the social charter. In Greece, the most important case law in this topic was 3220/2017 decree from the first instance court of Piraeus, which recognized the horizontal and direct effect of Article 24 of the European Social Charter, which is the right to protection in case of licensing. As for Belgium, a decree of the 26th of July 2017 of the Constitutional Court, which supports the principle of the right to lead a collective action. The constitutional judge mentions the practice of the European Committee of Social Rights, according to which the reservation of decision to start a strike only to representative trade unions or just representatives is a restriction which does not correspond to Article 6.4 of the Charter. As for Italy, for example, the Constitutional Court passed a decree number 194/18, which supports the Social Charter. But as for the conclusions and decisions about the base of the European Committee, it is said that they do not contradict, but still stress on the extensive interpretation, which is contrary to the principles of Italian Constitution. Another country, France. We have to note an obviously perceptible development in the 10 last years. In the very beginning, the administrative courts rejected the social charter. But finally, the Council of the State recognized for the first time the direct application of the position of the charter by decree, official decree of the 10th of February 2014. This decree recognized the direct application of only Article 24. After that, it was also admitted that the same direct effect was applied to Article 5. However, it confirmed the absence of direct application for other provisions in the European Social Charter in its revised form. The French judges for whom the Social Charter was put against either did not obviously respond to that or seemed to implicitly reject its direct application. This situation developed little by little in the opening more and more. As for the Cassation Court, it actually was put through a tendency of the social chamber to refer more regularly to that source and its motives. Also, its justification was not still explained. The topic, which was then put by the order number 2017, which is contrary for the judge, closing down in the guarantee for the workers, which were the object of licensing, that is still under discussion. There is still a question to know if this ban was compatible with Article 24 of the Charter in the revised form, and also with Article 10 of the ILO Convention number 158 about the licensing. However, the basic judges had different opinions about the conventionality of this ban, but also about the possibility to use international sources in this case. The Cassation Court denied the direct application of Article 24 of the Charter in the revised form in the proceedings between individuals. Also, it recognizes the direct application of Article 10 of the ILO Convention number 158, concluding about the conventionality of the French legislation. This rejection stopped the positive developments. Meanwhile, we are waiting for the decision about the European Committee of Social Rights about the first complaint that the French Trade Union have presented there. Summing up, all these examples show that the implementation of the Charter is possible to implement, but the road to success is paved with many obstacles. As for the specific country, Spain is an even more complicated case, which is going to be analyzed in the third part of my presentation, in the last one. So the reason that I'm doing that is actually in the continuation of great progress which we reached since 2013. In our times, this country is one of the most advanced in the field of efficient implementation of the Charter. The success in overcoming this challenge, the implementation, comes from the work of defendants and researchers of the Charter when faced with the deficit of knowledge. My country is now one of the most advanced as for the efficacy of the Charter. It is difficult, but still realistic. Fortunately, the legislative indifference did not hinder the progress of the judicial field. So how we managed to reach this success? The origin comes from the various legislative modifications that the Spanish government starting from 2012, after the conditions which were put by the European Union in exchange of the financial assistance which was received. With the aim, and we can actually affirm that most of the adopted reforms did not keep to the engagements as for the Charter. The firm persons which were affected started to demand in first instance courts versus an entrepreneur or a public entity that actually they did not respect the rights recognized by the Social Charter. Starting from 2013, the decisions of the first instance court started to recognize the rights as well as the control of conventionality in the European Social Charter, according to it, which is guaranteed by Article 96. And also by the law 25/2014 about the international treaties. Even if there was no unanimity, the judges of the first instance resisted in 2014 and later, and even more, worked more on other questions. First of all, the second instance court remained silent and even against it, but finally, starting from 2017, the decisions which validated some decisions of the first instance court started to be delivered. And this is how, in our days, we have achieved the direct effect of the European Social Charter and also the case law of the European Committee in seven questions. In particular, the support contract for the entrepreneurs and the probationary period of 12 months, which is not applied according to Article 4 of the Charter, the decision of the European Committee of Social Rights versus Greece. It was complaint number 65, and also the conclusions about Spain of 2014. Also, the re-evaluation of pensions was not applied in response to the direct application of Article 12 of the Charter. Well, the recognition of this period that was Article 2 of the Charter. Also, the guarantee of the minimum level of allocations, that's according to Article 13 of the European Social Charter. So this actually received a lot of support of the Constitutional Court decision. And I'm now talking about its decree of the 20th December 2018, which confirmed the first and the second instance court decisions, which concerned the control of conventionality. This decision is the most important in Spain in what concerns the control of conventionality, because it determines, on the one hand, this is a support of the first and the second instance courts, and on the other hand, the obligation and the right of lower instance courts to select the applicable law and to remove the law which does not conform to the treaty. Then in this way, we have reached three more questions, which apply this charter on the legal protection of the family, according to Article 17 of the Charter, the right to security, the work security after the licensing, that's according to Article 3 of the Charter, and the first, second, and 14th conclusions of the committee, and was the most remarkable, the exemptions of the abusive licensing of the status of workers, applying Article 24 of the Charter, and integrated in the International Convention of International Labour Organizations. So this synergy with the convention and the ILO, but the decisions were finally incorporated. In my opinion, these are actually the most notable expressions of the willingness to actually realize the implementation of the treaties of different organizations and also their efficacy. In conclusion, the implementation is realistic. We have to continue to work with the deficits that I have talked to you about, even if this challenge is difficult. I can say that the development and the social progress here can be stated for sure. It is necessary to remind and to require the states to adhere to the international obligations. If there is a passivity or the non-recognition from the side of responsible governments, the judges have to be guardians of the social rights efficacy. In my opinion, I managed to show you from the beginning of my presentation that the only thing that is necessary to implement the European Social Charter and the case law of the European Committee of Social Rights is to have the willingness to do that. I thank you for your attention, and I'm going to be available via email if you would like to get some additional information. Thanks a lot.
Щиро дякую, пані Кармен, за ваш
Thank you very much, Carmen, for your presentation. In fact, the subject is very difficult. The language is quite difficult. I think we will have to need more time to understand this subject better. But the main thing that we can definitely perceive and understand is that the judges can and should be those first people who would start to use as broadly as possible the European Social Charter and the case law of the European Committee on Social Rights, well, at least by starting with opinions about Ukraine, and of course, with all the other decisions and opinions of the European Committee of Social Rights that can help judges motivate certain decisions and judgments, the Ukrainian judges, because most probably any issue related to violation of social rights would anyway be they have been reviewed by the European Committee of Social Rights, and those interpretations of the European Committee and their application in Ukraine can already be evaluated, can already treated as the use of the case law of the European Court, when we did not yet have the law in Ukraine saying that the case law of the European Court is binding for Ukrainian courts. I think that for now it's quite difficult for us to imagine what kind of application this can be. But as soon as we start doing that, I very much hope that our project will help doing that. And we will all understand that this is really very important. Unfortunately, we do not have a chance to ask questions, to put questions to every expert. But after this session, we will have time for questions and answers for the general discussion. And you can always put your questions in the special column of Q&A. We have received a general review of the social rights guaranteed by the European Social Charter and the best practices of certain member nations in order to use the case law of the European Committee of Social Rights on the national level. But here we would like to emphasize how the European Social Charter and the case law of the European Committee should be exercised by the administrative courts, and what possibilities is opened up for the administrative courts of Ukraine, and what is the practical approach of Poland, a neighboring country. What are the challenges and possibilities to use the European Social Charter and the European Committee of Social Rights case law? And I'd like to give the floor now to Ms. Monika Smysz-Kulesh, international consultant of the Council of Europe project promoting social human rights as a key factor of sustainable democracy in Ukraine, who's the judge of district court in Łódź, Śródmieście, Poland, doctor of law, lecturer at the University of Łódź, Department of Law and Administration. Monica, the floor is yours.
Monica, your microphone is turned off, just in case you didn't know.
Thank you very much, Susanna. I hope now I can start my speech. Distinguished guests, ladies and gentlemen, it's my honor to be here with you today and to present European Social Charter as an international instrument for protection of social rights, also in or with special attention paid to administrative justice. And it's my great pleasure to speak in front of such a highly professional audience. In the first words of my speech, I would like to express my strong gratitude to the Council of Europe and its office in Ukraine for mandating me to make the presentation as the representative of the Council of Europe during such a valuable webinar. My presentation will consist of 3 parts. I will start with very, very brief introductory remarks. Then I will concentrate on the best practices of applying European Social Charter and the case law of the Committee of Social Rights, first by Polish administrative courts, and then I will turn to international courts. Finally, the last part of my speech will be devoted to challenges and opportunities connected with applying the Charter as an international instrument for protection of social rights. The aim of my presentation is to prove that the Charter and the case law of the Committee can and should be used by all courts, of course, but today we are concentrating at administrative courts, so I will try to put as much attention as I only can on the fields in which administrative courts specialize. To protect social rights, especially of the most vulnerable groups of the society. And my second goal, very important goal, because today I am speaking in front of judges. Of course, not only judges, but the audience includes judges. My second goal is to share best practices of applying the Charter and the case law of the Committee, and this way to encourage national judges to apply the Charter and the case law of the Committee dealt with in cases dealt with at all levels. I hope I will manage to encourage as many judges to apply the Charter as it is only possible. So first of all, as I told you, I will start with some introductory remarks very, very briefly. So the European Social Charter, as it has been said before, is a Council of Europe treaty that guarantees fundamental social and economic rights, and it is a counterpart to the European Convention on Human Rights, which refers to civil and political rights. The Charter of Fundamental Rights guarantees a broad range of everyday human rights related to employment, housing, health, education, social protection, welfare. We all know it very well. The Charter, which is very important, lays a specific emphasis on the protection of vulnerable persons. For example, which was also said today, which has also been said today, such as elderly people, children, people with disabilities, migrants. And it requires that enjoyment of all the rights guaranteed in the Charter should be applied without discrimination to all the people, including those most vulnerable. No other legal instrument at pan-European level can provide such an extensive and complete protection of social rights that is provided by the Charter. And what is worth stressing, the Charter serves as a point of reference in European Union law. I will turn to it in the second part of my presentation. I will show that even the European Court of Justice turns to European Social Charter and to the makes references to the case law of the European Committee of Social Rights. So the Charter is seen as the social constitution of Europe and represents an essential component of the continent's human rights architecture. The honoring of commitments entered into under the Charter by the parties is subject to the supervision of the European Committee of Social Rights. This is a monitoring body that consists of independent, impartial members who are elected by the Council of Europe's Committee of Ministers for a period of 6 years. The committee monitors compliance with the Charter under two complementary mechanisms. It was introduced today by Mrs. Giuseppe Palmisano, the President of the European Committee of Social Rights. So not to say twice the same, I will just mention that there are two procedures: the collective complaints procedure and the reporting system. And within those two procedures, the committee checks compliance of regulations of states with the Charter. And insofar, which was also stressed by Mr. Giuseppe Palmisano, insofar as they refer to binding legal provisions and are adopted by a monitoring body established by the Charter and relevant protocols, the decisions and the conclusions of the committee must be respected by the states concerned. And even if they are not directly enforceable in the domestic legal systems, they set out the law and can provide basis for positive developments in social rights through legislation and case law at the national level. And now turning to best practices of applying the European Social Charter and the case law of the committee in administrative justice, I would like to start with national level. And I would like to concentrate on Polish example, first of all, because this is the example that I know quite well. And secondly, because Poland and Ukraine are close neighbors, the economies of both countries are at similar level. And I think that both countries may and should change their experience for increasing the protection of social rights, and especially the protection of rights of the most vulnerable groups of society. At the beginning, it must be stressed that both Poland and Ukraine have ratified the European Social Charter, though Ukraine ratified the revised European Social Charter, and Poland ratified only the first, the 1961 European Social Charter. It has not ratified yet the revised European Social Charter. Neither Ukraine nor Poland have accepted the system of collective complaints. Turning to best practices from Poland, I would like to present some statistics. And in the official state database of administrative courts judgments, there are nearly 1,840,000 judgments of regional administrative courts and the Supreme Administrative Court of Poland. And unfortunately, references to the European Social Charter can be found only in 167 judgments. But what is maybe worth stressing, last two out of this over 160 are dated September 2020. So I think it proves the tendency to use European Social Charter more and more often last time. Unfortunately, in the database, in the official database of administrative judgments in Poland, there are no references to the interpretations of the Charter made by the European Committee of Social Rights. Looking at those judgments which are, I think, worth mentioning and which can show the practice of applying European Social Charter at national level, I would like to show some quotations from judgments. I will not speak about judgments as such, because this is not my point. I would just like to stress the situations in which European Social Charter is applied and the way in which Polish courts apply this charter and include some references to the charter in their judgments. So first of all, I have chosen the resolution of Administrative Court of the Supreme Administrative Court from 2006. In my opinion, this is important. Judgment because in this judgment, the Supreme Administrative Court of Poland used the European Social Charter as a base for the interpretation of the key term in the case. The key term of the case was to interpret the scope of the term social security under the Act on Social Security System. And while interpreting this term, the Supreme Administrative Court of Poland turned to international legal terminology, stressing that it is obligation of each country, which is a member of the Council of Europe, to understand, to interpret the terms of national acts in the light of international obligations, which is obvious, of course, but it was stressed. And the interpretation given to the term social security was the interpretation done in the light of the European Social Charter. The court stressed that in the countries that ratified the European Social Charter, such interpretation is an obligation, and stressed that the fact of ratification of the Charter lists Poland among those European countries whose special security system must meet the standards which are invoked in the Charter, and here in ILO Convention, which is also turned to by the Charter. Next example is the judgment from year 2009. And in this case, the court had to provide interpretation of the regulation of granting pensions as a way of exemption for especially vulnerable persons in case of failure to comply with the standard requirements under the legislation on pensions from the Social Security Fund. Here, the Supreme Administrative Court of Poland also turned to international obligations and applied European Social Charter, stressing that those regulations express states' responsibility towards the international community to encourage elimination of unemployment and ensuring work for all citizens, and in case of failing to comply with the obligation, to provide such citizens with social security, enabling them life in conditions not violating human dignity. Nevertheless, the court stressed that Article 13 of the European Social Charter does not provide for autonomous legal base for public authority acts, but expresses an idea from which values shaping citizens' rights and obligations shall be derived. And the court stressed that thus it must be understood as basis for interpretation and application of law by public authority. So I have chosen this judgment to prove that even if the charter or particular provision from the charter was not used to interpret particular provision, particular term, still the Supreme Administrative Court used European Social Charter, stressing that it must be understood as basis for interpretation and application of law by public authority. Now I will turn to best practices from international level. I will turn to best practices from European Court of Human Rights. This will be our first court to look at. And in the last part, I will turn to the Court of Justice of the European Union. So first judgment of the Court of Human Rights, which I have chosen, is the case of Baykara versus Turkey. And I've chosen this judgment due to its very important inclusion of the provisions of the European Social Charter by the European Court of Human Rights. And the case considered the right, the basic part of the case, the basic right that was dealt with in the case was the right to organize. And the European Court of Human Rights, interpreting the scope of this very important right, turned to European Social Charter and decided that the right to organize had a negative aspect which excluded closed shop agreements, and the court considered largely on the basis of the European Social Charter. So this judgment gives an excellent example that European Social Charter is perceived as a base to shape, to interpret most basic provisions, most basic rights, most basic terms by the Court of Human Rights, who quotes in its judgments the Charter itself, and here referred to Article 6, paragraph 2. My next example by the European Court of Human Rights presents another attitude of the European Court of Human Rights and another way of using the whole values given by the European Social Charter. In this judgment, the European Court of Human Rights turned not to Charter itself, but included quotation from the decision, from conclusions by the European Committee of Social Rights. So this judgment by the European Court of Human Rights shows that not only the text of the Charter itself can and shall be used by the courts, but also the case law of the European Committee of Social Rights. And in this case, the European Court of Human Rights interpreted the right to social security and the right to physically or mentally disabled person to vocational training, rehabilitation, and social resettlement. And the European Court of Human Rights turned to the case law of the European Committee of Social Rights and quoted conclusions concerning Finland and concerning Article 12, paragraph 3. Last case, which I have chosen from the rich jurisprudence of European Court of Human Rights, turning to European Social Charter and to the case law of the Committee of Social Rights, is an example of Ukrainian case, which I think you all know perfectly well. But this case is worth mentioning not only because it is a Ukrainian case, but also as an example of another attitude towards using the Charter and the case law of the committee. Because in this Charter, in this judgment, the European Court of Human Rights quoted the digest itself, showing this instrument and using the interpretation which was given to one of the articles of the Charter in the digest of the case law of the Committee of Human Rights. And the European Court of Human Rights interpreted the right to bargain collectively, in this case of Tymoshenko and others versus Ukraine. And the court turned to interpretation of Article 6, paragraph 4 of the European Social Charter, and turned directly to the digest of the case law of the European Committee of Social Rights, quoting the interpretation given by the European Committee of Social Rights to Article 6. Now I will turn to the Court of Justice of European Union to show that the Charter is valued also by this tribunal, and to stress that the Charter is a base for lots of European Union documents, which so shall be interpreted in the light of the European Social Charter, which is stressed by the Court of Justice of European Union. So the first case which I have chosen, it's a case, very, very fresh case from September 2020. This is, these are joint cases. The key aspect here was the right to paid annual leave, and the Court of Justice interpreting the scope of this right under European Union regulations and directly to the European Social Charter, and showed and stressed that regulations of European Union, the provisions of Act of European Union in this matter are based on Article 2 of the European Social Charter, among others, of course. Article 2 of European Social Charter guarantees the provision of a minimum of 4 weeks of paid annual leaves. And the Court of Justice of European Union stressed that as Article 2 of the Charter was the base for regulations of European Union, the regulations of European Union must be read in the light of European Social Charter. The second judgment from the Court of Justice of European Union, which I have chosen, is a little bit older. This is to the year 2006. And the key aspect of this case was the right to family reunification of minor children of third country nationals. And I have chosen this judgment to show another way of quoting European Social Charter by the Court of Justice. It can be seen in a group of judgments in which the Court of Justice stresses that according to here one of the directives, the provisions of this directive are without prejudice to more favorable provisions of the European Social Charter. And here, in this judgment and in the judgments which are similar to this, the Court of Justice of European Union stresses the fact that the Charter very often gives benefits which are larger than the minimum regulations of the European Union. And of course, in the regulated sphere, the directives are without prejudice to more favorable provisions of the European Social Charter. The last example is the example from the case from 2018. And this is quoted from the case 684, but this is a clause which is used very often in the judgments of the Court of Justice of the European Union. And according to the pursuant to this clause, that any principle is itself mainly derived both from instruments drawn up by the member states at EU level, such as the Community Charter of the Fundamental Social Rights of Workers, which is moreover mentioned in the treaty, and from international instruments on which the member states have cooperated to or to which they are party. Among them, there is the European Social Charter, to which all member states are parties. Among them is the European Social Charter, to which all member states are parties, insofar as they are party to it in its original version, its revised version, or in both versions, also referred in the treaty. Such a clause is very often used by the Court of Justice of European Union, which highlights this way the importance of the Charter and which places the Charter as one of the most important human rights treaties in the European sphere. So this is the widest and the least concrete application of the charter, but still it's very important to stress that such often clause used in the judgments of European Court of Human Rights, European Court of Justice of European Union, stresses the importance of this document and shows that it can be used as a standard quoted in the judgments. Now turning to conclusions. European Social Charter is an instrument for protection of social rights, and what must be stressed can and should be used in Ukrainian administrative justice as an instrument for protection of social rights, and especially for protection of the rights of vulnerable groups. Of course, it is very important for the Charter to be used and invoked by all legal professionals involved in administrative court proceedings, and not only by the court, but also by advocates, for example, who take part in administrative court proceedings. And this Charter and its interpretations given by the committee should provide proper interpretation of Ukrainian regulations and can strengthen way of reasoning under particular regulations which are applied in the case, in a particular case. Best practices from both national and international level show that the Charter can be especially useful while, first of all, interpreting legal terms, secondly, determining the scope of particular rights, and thirdly, the understanding of particular rights. What are the challenges and opportunities of applying European Social Charter? Of course, I hope that my presentation showed that both the text of the Charter and the interpretations of this text given by the European Committee of Social Rights in different forms, in form of conclusion, in form of decisions, can be used in the judgments. It's worth stressing that the committee issues conclusions in which it gives broad interpretation of the understanding of particular provisions of the Charter, and concludes if regulations of a particular state comply with obligations under the Charter. The latest conclusions concerning Ukraine have been translated, as far as I know, into Ukrainian language and are available online. I'm here presenting the link, so all interested in getting familiar with this conclusions can easily do it in Ukrainian language. Looking further at the challenges and opportunities of using the European Social Charter, I would like to stress four instruments. So first of all, the easiest and the most comfortable tool that can be used to get familiar with the Charter and the interpretations of the Charter made by the European Committee of Social Rights is the digest of the case law of the European Committee of Social Rights. The latest digest now available is dated December 2018, and it can be reached via internet. And this is a huge instrument giving knowledge about the about the case law of the European Committee of Human Rights. There are also e-learning courses on European Social Charter provided by the Council of Europe in the frames of help learning courses. I can give an example of labor rights as human rights, which is available in Ukrainian language. It can also be easily found on help platform of the Council of Europe. Of course, the most comprehensive database of conclusions and decisions of the European Committee of Social Rights can be found in HUDOC database. So HUDOC database is the richest source of knowledge about the interpretations of the European Social Charter. And soon there will be another very valuable material for Ukrainian judges, and it will be available. And it will be the training program for judges on European Social Charter and the case law of the European Committee of Social Rights. This program is in the process of drafting, and I think that today Ms. Zuzanna Mnatskanian will speak about this program at the end of our conference. So I hope everyone will get familiar with this part of the project, which will be especially dedicated to judges. Thank you very much for your attention.
Щиро дякую, пані Моніко, за
Thank you very much, Monica, for your intervention, for this practical advice about how it is best to start applying the European Social Charter and the case law of the European Committee by the courts of Ukraine. It's true that all of those instruments are very effective, including the digest in particular. I would like to stress that the digest is permanently, constantly updated. Now, for example, it's also on the update stage. As soon as we get the final version of the digest, the most recent one, we will also translate it into Ukrainian to make it easy for the Ukrainian judges to apply it, because it's really a unique document, a collection, a compendium of interpretation of the social rights guaranteed by the European Social Charter. Thank you very much for your presentation. I think we can say that we have finished the presentations by our international experts who told us about the general characteristics of the social rights guaranteed by the European Charter as regards the case law, the European Committee of Social Rights. And now we will proceed to our kind of a second part of this first session. We will talk about the right of the IDPs, the rights they have in the areas that are not controlled by the government. And we will ask Lilian Apostle, international consultant of the Council of Europe Project Internal Displacement in Ukraine, Building Solutions. He is the resigned government agent of the government of Moldova to the European Court of Human Rights. Lilian, the floor is yours.
Thanks, Susanna. I assume that you hear me well. And good morning, everyone.
Can you speak louder, please, a little bit, or move closer because your sound is low?
Okay, I think now it's okay. Susanna, yeah? It has to adapt itself. Not only me, I have to adapt myself to the presentations. And I will start right to the point. I will share my presentation. Unfortunately, it is prepared only in English. But I think if my presentation will be helpful for you, I think, well, the project will translate it, because I prepared a lot of references and materials. Basically, my presentation refers to the study that we made for the project concerning a couple of social security rights, I would say. Right to housing, health, and well, my part was social security rights in general. How they are being protected in times of, well, difficult times, when IDPs do not, when the government do not have an effective control over the certain areas. And imagine that such a subject was, I think, difficult even for me, even with my experience of having a lot of cases coming from our Transnistrian region when we actually face quite similar situation. I will provide the details. I will provide a comparative analysis laterly, as you see in this section concerning selected practices. But before doing that, I would like to make a brief overview of international standards in this area, because without this overview, I don't think we will understand deeply how the social security rights should be protected in those areas or in connection with these areas. And let me very briefly overview these standards, because we already had a very good and deep analysis of the social security, of European social security, social charter and its framework. However, when I started my analysis, I started analysis from the top, from universal principles. I will not go deep in these universal principles of how social security rights are being guaranteed on the universal level, but we cannot ignore them. And I think you as the judges will agree with me, because when a judge deals with the case, with the social security case, he or she should identify the relevant principles, the basic principles, the sources, the basic sources, how to resolve these cases. And that is why my task is actually to somehow guide you, you as the judges, to guide you how you should approach these rights, even in these difficult situations when IDP comes from or still lives in the government non-control area. So we have UN General Framework, of course. This is International Covenant on Economic, Social, and Cultural Rights. From there, all rights took inspiration from. And then we have quite good guiding principles that I selected some principles that could be relevant in particular when it comes to the IDPs, because this guiding principle in general, international covenant does not regulate only the IDP's rights, social rights, of course. It regulates a lot of other rights, of course. But from these guiding principles of UN guiding principles, I try to identify at least some relevant principles that could be useful for you when we examine a particular situation, when you have the difficulty to apply these rights in those areas. And these are two guiding principles here that in these particular situations we may involve protection of social security rights when necessary. And second element that actually does not precisely concern social security rights, it concerns more or less privacy rights. This is identity documents, the right to identity documents, the right to have some recognition in spite of the principle of non-recognition. I will tell you later why I selected this, because this is precisely the point. This is precisely the difficulty in dealing with all rights, not only social security rights, with all rights of the people coming from non-recognized territories. So that is why I just selected them. I will not go through them as I told you. I will explain them laterly, why they are relevant for us. And another part that actually I looked in, this was I think, one of the most relevant rights These are rights, work-related entitlements, as they are being called, because International Labor Organization actually examined in more detail the problems of IDPs, in particular in this recommendation. That is why I just choose these relevant international universal sources. So how to read these international, basically these international sources, legal sources. So, well, of course, you as a judges, you understand that when it comes to the problem of non-recognized entities and the territories out of control, we always have the problem of jurisdiction. I will tell you this again later when I will refer to the European Court jurisprudence. Well, the problem was in particular with social security rights, that the problem of jurisdiction was very well dealt, well examined when it comes to civil and political rights. When it comes to social security rights, and this is actually the reference to the International Court of Justice, when it comes to civil and political rights, Covenant on Civil and Political Rights, there we have this doctrine of effective control. So basically the idea is that human rights should be guaranteed by those states who have effective control over territory. So this, I think this is a reasonable question for you, why we, without effective control, how we can guarantee social security rights and in general, any rights in those areas. What are our obligations? And I think this dilemma was tried to be solved by so-called Maastricht principles on extraterritorial obligations. Of course, as you see, these principles refers mostly on extraterritorial obligations of the states in social security rights. Well, some of the references you could find on the parent state duties, as they called, in our case, Ukraine. In cases when the parent state lost effective control over territories, what are their obligations when we have actually the clash between control coming from another state and loss of control of the parent state control. So it is a difficult topic. I will not go deep in this topic because it will occupy the whole day. I'm just making the reference to the sources where you can find the answers, because the first task of any judge is actually to identify the relevant applicable international principles in our case, because IDP it is an international problem. So that is why my task is actually to show you the sources and where you can find the answers, where you can rely on the answers. And in the rest, when we speak about the substance of the rights, of course, I identify the principles, the key elements of state obligations, that these social and economic rights, they are self-imposed. Should be basically chosen by the state. In other words, the states have a large discretion in this area. They should be implemented without any discrimination. And when it comes to ITPs, I refer to the general comments of UN Committee on Economic and Social and Cultural Rights. And this is the paragraph referring how IDPs should be treated from the perspective of social security rights. So this would be relevant because they are here we have these basic elements of the state's obligations. So when it comes to the regional protection, and here I will be in more detailed in my explanations. Regional protection, this is, we mostly refer to the, of course, to the Council of Europe. I left aside the protection granted by European Human Rights Charter, which is quite advanced in in guaranteeing social rights. But Ukraine is not a part of European Union, so unfortunately we will be dealing only with the framework granted by the Council of Europe. And this framework, as you already know from presentations of previous speakers, is made basically by 3 pillars. This is some of the recommendations of the Committee of Ministers, is providing a general framework. I chose to look only on some recommendations, particularly dealing with the problems of the IDPs, not in general social security rights. There are a lot of recommendations on that regard. But here I tried to find sources in the Committee of Ministers, documents, recommendations, guiding principles, and so on, decisions, and so on, focused on IDPs' rights. And as you see, the Committee of Ministers usually focus on these rights. Housing rights, it focuses on the compensation for the loss of properties. It focuses on state obligations, granting restitution for these rights, and an investigation of serious human rights violations. So when it comes to, in particular, social security rights, social benefits, Committee of Ministers is quite silent on this regard, and what I found is these recommendations, when we have actually the general need of IDPs reintegration. So this reintegration presupposes granting some social security rights, of course. And this reintegration includes, by the way, the right to have an identity document. Again, this topic I will explain a bit later. So in general, when we look into the sources of the Committee of Ministers, we have this problem that social security rights usually are referred to the jurisprudence of the European Social Charter and Committee of European Social Charter. So European Social Committee, European Social Charter, sorry, again, it regulates in general, as it was told already, this is the social constitution of Europe. It regulates in general all social security rights, in particular in our case, this is one of the basic sources of law, Article 12. And again, here I didn't find clear references to IDPs. In general, the committee identifies IDPs and grant them the same refugee status. This is usual practice of any tribunal, international tribunal or national tribunal, because it is the only difference of IDPs and refugees. This is that they are internally displacement. That is why they are called IDPs, internally displacement. But actually they benefit from the same panoply of rights as a refugee, so the same protection. But of course they have their particularities, and this is our task today, to examine, to find these particularities. So another key principles that I derived that are very relevant for the IDPs and social security and their rights and to social security. These, of course, these basic principles is a progressive implementation and well, disregard of territoriality or nationality aspect. Basically, from the perspective of non-discrimination, of right to non-discrimination. And of course, another aspect that we could also discuss, this is portability of the rights. And well, I will explain this in details when we will go on the practice. Now, of course, the most relevant, I think, source of law, and the most popular source of law for judges in Ukraine, this is European Court. It's jurisprudence. It was already, my previous speakers already referred to some cases in the European Court, so I'll be moving quite speedily in this sense. But I would like to say that we actually have three types of cases before European Court concerning social security rights. These the problems when some of social security rights were kept intact, though they need to be changed, and this raised some problems from the perspective of European Convention. Second problem, this when social security rights were revoked or lifted, and I think this is one of the problems in Ukraine, and I will refer to some cases in Ukraine. And another miscellaneous problems that we actually will just, I will illustrate only for the purposes of comparison. So this is the jurisprudence of the court, basically summarized by me when the social security rights were kept. And these problems never involved the problem of jurisdiction or the problem of non-controlled territories and so on. Apart from these cases where we have, well, basically the consequences of war. But this is basically the problems that European states faced when they kept some social security rights, though the applicants choose to comply against them because they were not convenient to the applicants. So I don't think we need actually to go in these details because this is not a situation in Ukraine, but for the purposes of knowing how the convention, European Convention, protects social security rights, you can look in these cases because these are basically the cases that extended the application of European Convention over the social and economic rights. Why I'm saying this? Because as you know for sure that European Convention is not a social and economic convention. Granting it doesn't guarantee this convention. It is a civil and political rights. So there was always a dilemma why European Court is actually dealing with these rights. And I will explain a bit later how it deals with these rights. The second problem of in regard to these rights, this is problem when we have a reduction of social security rights, or in general, annulment of these rights, lifting these rights at all. So this problem was examined by the well-known Velikada decision. This problem was examined by systemic cases, in respect of Moldova, this was Olaru and others. We have to annul some housing rights in order to deal with social security, have somehow to resolve the systemic problem. This is the same problem in Ukraine when we have Burmich, and in the framework of Burmich and Ivanov execution, there is a strong commitment actually to abolish some of social security rights, because they give you the problem, they raise the problem, and in order to confine the problem in Ukraine, you have to review this all social security system. These are particular cases, again, when some of the salary rights, for example, in Bosnia and Herzegovina, were either excessive or either discriminatory established. And these cases shows how states, how Bosnia and Herzegovina resolved this problem only by reviewing and abolishing some rights. Another problem that could be relevant for Ukraine, this case when in order to guarantee social security rights, execution, enforcement of these social security rights, Turkey removed moratoria and lift immunities from the budget of from the local budgets. So these are just the examples. Again, I will not go into the detail. I think one of the most difficult problem for Ukraine when it comes to the social security rights, to the guarantee of these rights, this is frequent changes in legislations, and how these changes of legislation actually influence the granting of social rights. And this problem is usually examined by the European Court from the perspective of legal certainty. I derived some, I think, principles that could guide administrative courts in Ukraine how to resolve the problem of legal certainty. In other words, the problem is quite simple. To what extent we need to keep social security rights as they were granted previously by the courts? How and to what extent we need if the legislations in the meantime was changed by the parliament, by the Verkhovna Rada. So here we have certain principles already derived. So if changes in social legislations will not affect the litigious claims, be very careful in this sense. Next, we have another principle that changes in legislation could not affect the process of execution already. If you have an enforcement of previous judgment granting social security rights, or here we have economic rights, but the principle is the same. The changes in legislation could not make this execution impractical. And the next changes of legislation could not, of course, be applied retroactively, which was also the case, for example, in this case. Strangely enough, but it was applied retroactively. And when you change the legislation, when the legislation is changed, and this is also concerns not only the changes of legislation, but also the changes of judicial practice, there is always needs to be a general interest need to be proven. So you cannot just change the legislation because, well, you don't have money. This is not an explanation. You need a general interest in order to prove that actually social security rights could not be guaranteed as they were guaranteed previously. This is precisely the problem what was examined in the Velikada decision. legislation was changed. They changed the calculation established previously by Ukrainian courts, and the European court actually agreed that this change, this new way of calculation of social security benefits was actually in line with the general interest of the claim. So public interest actually prevailed over the individual interest. This is quite interesting decision. And there, the court actually explained how changes of social legislation could be done. This is a recent decision of, again, against Ukraine, Kandiba. I saw this decision only yesterday when I prepared myself, but I think this decision will be one of the main subjects of today's discussion, because it precisely concerns the conflict between Ukrainian courts, administrative courts in general, and the government. Ukrainian courts annulled some resolutions of the government, and precisely concerning the claims of IDPs or of the person who resides in the territory, in the territories outside of the governmental control. These persons complained against changing of social security benefits, method of payments, of course, amount of payments, and the courts granted them relief. They annulled resolutions, and still these judgments of the administrative courts, I think, were not enforced. So the applicants complained before the European Court, and the European Court dismissed their claims. So here we have quite interesting reasoning of the European Court. I will not go into the detail because I have to move myself into the problem of, into the explanation of the general practices of the pan-European states in social security area, in particular when it comes to problem of granting social security rights to IDP outside of the effective control. But I think I raised some questions, and the interest. So we need to move ourselves into this area. So these are basically the general requirements in the social in the rights in the guaranteed rights of IDPs in social security area. First, all sources are relevant on the regional level. Both European Social Charter and European Convention on Human Rights could be invoked by the judges. When you deal with these problems, you should look on the both sources of law equally. A large discretion, it is still given to the state. You need, as a judges, actually to examine the balance between the individual interest and the public interest. You should take into account that social security rights usually are being guided by progressive implementation. What does it mean? You cannot grant these rights right and now. You have to actually look into the perspective, and this is what quite difficult decision to make. Again, always social security rights should be granted without any discrimination. However, when it comes to IDPs coming from non-controlled government territories, you have actually to grant them positive discrimination, and I will explain this a bit later. And this again, this principle of proportionality between individual and public interest, I already explained. So now we move ourselves to selected practices, and I will go through them again quite rapidly. So basically, when we have the problem of IDPs and their social rights, we have two situations to examine. These are the states having territorial secession, which is unfortunately the case of Ukraine, and different type of approach to social rights when states are in the post-conflict situations. I call them post-bellum situation, when the conflict actually stopped and there is a need for reconciliation, need for transitional justice, and so on. So when you examine the cases, you have to get inspired from either one or another situation, because approach is quite different. It's quite different, and you will see why. When it comes to states practice still facing territorial secession, we have, of course, the most relevant example is Cyprus. You have to look into the origins of the conflict. Here in Cyprus, we have origin of the conflict, rather intercommunal conflict. I do not say internet and ethnic conflict. Still in Cyprus, we have a stumbling block, non-recognition on part of the official government of Cyprus. However, this non-recognition was overcome by Cyprus when they started granting some primary civil status to residents coming from that region. Some special treatment was granted, but the problem of social rights in particular was solved when Cyprus adopted all-inclusive policy. They started recognizing the persons as citizens, and this became a good practice when Cyprus passport became quite promptly attractive for the people coming from that region. So there was no need actually to a separate social security policy for that person, because they were granted the citizenship, and well, they benefited from the social security rights as well as any citizen. Still, the problem remained with the system because it was contributory based. The citizens coming from that region should pay their contributions in order to benefit from social rights. But the problem how they paid this contribution was also raised. And some of the treatment basing on different ethnic origins was still remained embedded in the legislation. So this is example of Cyprus. This example of Republic of Moldova is quite similar to the policies, I think, that Ukraine adopts in its country. We have a geopolitical frozen conflict. We have still formal non-recognition of the territory, but Moldova grants civil status documents, recognize citizenship, and even exchange social security rights with non-recognized authorities. And we actually face there are two different systems of social security. IDPs were, as I told you, were granted the citizenship, and they were granted special status, but they were never recognized as IDPs, as it was case in Georgia. In Georgia, we have a special dedicated system of recognizing IDPs. but this system is based on ethnic principles, on ethnicity. And I think this is a problem because, well, as I told you, the problem, the social security rights should be granted without any discrimination. And, well, these policies could be somehow treated, qualified as such. But, well, as I told you, you need to understand the context of this conflict, and the conflict is interethnic. That is why we have these policies: no double citizenship, no absolute allegiance, and, well, we have even some targeted social assistance to the people coming from that region, basing on ethnicity. So the situation in Georgia merits attention because, as I told you, they are being based but on absolute non-recognition policies, but still Georgia recognized special IDP status. So you may get inspired from that. In Azerbaijan, this is the, well, I think in the context of recent events, their policies are quite questionable even now, because they grant IDP status only to Azeri, and well, they are also being based on absolute non-recognition, even animosity against settlers in the non-government controlled territories, and unwillingness to implement special social security policies in that region. So this is, well, probably not the case to get inspired from, but the case that needed be to examine. Well, these actually situations were examined only for the comparative purposes. This mostly the states facing post-balance situation after Yugoslav wars, and their problems, well, are quite complex. Even now we have the consequences of their policies. This is first the policy in Croatia to grant special validation to all IDPs, but the problem was of a legal character, no clear administrative mechanism, no clear jurisprudence of the administrative courts, no clear judicial review. So the legislation was in itself is quite problematic, and this created a lot of problems for Croatia in terms of their administrative justice, and created a systemic problem. So if you would like to avoid this type of situation, you need to look in the example of Croatia how not to validate some acts, because you certainly will have the same problem of validating some acts issued by non-recognized authorities. In Bosnia and Herzegovina, there is a quite complex problem. I will not deal with that. I just will show you that the problem there lied in the federative division of the country, and two different types of social security systems, which is not the case in Ukraine. But if there is an idea in Ukraine, for example, to introduce a separate social security systems, I don't think that will be the case. I don't think that Ukraine will be happily will resolve the problems by two separate social security systems, as is, for example, is it the case in the Republic of Moldova, when we have two parallel social security systems and they are concurrent. This is not a good idea. So that is why I showed the Bosnia and Herzegovina case again, how not to do the things. Serbia could be inspired for you because they resolved the problem of their non-recognition in the situation of Kosovo. They instituted a special mechanism of recognition of social security rights granted by the courts in Kosovo, and they were enforced, and now are being enforced in the territory of Serbia. So that is why we have, again, a mechanism that Ukraine could be inspired from. This is the Grudzic decision and systemic problem results. Slovenia, this is my last example in my presentation. This is the problem actually not particularly referred to the problem of granting social security rights, but the problem of so-called erased people who were not given a proper identity documents. So without documents, without even some official recognition of the person in general of the identity, you cannot speak about any social security, right? So that is why granting some recognition, granting documents, issuing passports, identity documents, certificates is a very important step to secure and to protect social security rights. So that is why, again, when you deal with this problem, do not forget about the privacy. Do not forget about the erased person. And well, I think for the judges it could be relevant because usually you deal with the cases when the person comes and without any documents, without any proof, without any property even documents, and then asks the court to recognize the right and so on. So I think I somehow guide you where you should look, and well, I just stop here because I a bit extended my presentation 5 minutes at least, and these are my conclusions. Even if social security rights, usually I consider it as less priority, this is not the case when it comes to IDPs, because by recognizing IDPs' rights, you will integrate the territory by people living there. So this is the policy coming from experience of many countries facing territorial secession, Cyprus, Moldova. This is a good policy. So pro-human rights approach. You should grant these persons special status. And despite of having large discretion in granting social security rights, be aware of non-discrimination, and on the other hand, you actually should give a special status, so positively to discriminate. You have to positively discriminate these people because they are in a vulnerable situation and require special treatment. Take into consideration that all social security rights have to be implemented progressively. And I think you have to explain to people coming to a judge that I cannot guarantee this right now and immediately, but the state should look into the perspective, should implement policies into the perspective, and the judge should take this into consideration. Of course, all-inclusiveness, this is the basic principle. Do not forget that nationality and citizenship is not the basic criteria for granting social security rights. Still, if you have the problems of citizenship, allegiance, and so on, these problems should be solved in such a way so that protection of social security rights will not be affected. And last conclusion, lack of effective control of the state over the territory does not dispel the state, and in particular courts, from the obligations to do whatever possible to grant people living there and coming from there with certain rights, which is this is a situation in case of territorial secessions. In other situations, when the conflict has gone, the approach is a bit different. You should not forget about the non-discrimination principle. Thank you, and I'll be able to answer your questions. Thank you.
Щиро дякую вам, пане Ліліане.
Thank you very much, Lillian, for having presented the international standards, for having shown us the best practices as regards protection of the social rights of the IDPs, of that international practice, which Ukraine should not apply. All of it was very useful. Thank you very much for this very detailed intervention. Before I give the floor to our next speaker, I'd like to remind you that in 15 minutes, we will have a chance to discuss all those issues that have been raised here. So if you have any specific questions, please write them down in chat or raise your hand. We have such a button there in this platform. If you raise your hand, that means that the moderators will move you to another group of panelists, and you would be able to turn your microphone on, turn your camera on, and ask your question that interests you. In other cases, if you don't want to do that, please just write your question and we'll be able to discuss it. So now I'd like to give the floor in this first panel session to close it down. In fact, my colleague, Hanna Kristova, who is the Senior Project Officer of the Council of Europe Project, Internal Displacement in Ukraine, Building Solutions. She's a Doctor of Law. So you, Hanna, could tell us about the Council of Europe Help Course on Internal Displacement. Hanna, the floor is yours. Thank you, dear Susanna. Thank you, dear participants of this webinar. That is very important for us. We're very happy that in the welcoming words, our colleagues who are the top executives of the Cassation Administrative Court, the National School of Judges, Olena Litvinenko, all have mentioned our many years of experience of cooperation in our work, developing some useful materials that we then share with the judiciary so that they can study them and use them. This area of our project's work is extremely important because we all remember the position of the European Court on Human Rights that very clearly stresses human rights should not be theoretical and illusory, but practical and effective. ID versus Ireland, we'll know that case very well. It's a symbolic case that in fact set the main objectives, including for our project work. And as our project deals with protection of human rights, including social rights of the internally displaced persons, so our activities take place around this problem. As we understand that we already have quite a lot of fatigue after all those extremely interesting presentations that you have listened via interpretation. And of course, it makes perception always more difficult when we're talking about very difficult legal constructions. So there is nothing surprising for us. My presentation, first of all, would be very brief, so we have more time for questions. And second, it will rather deal with a resource, which we hope should be useful for you in order to get this kind of a concentrated information on the issues of legal standards in terms of internal displacement and the national legislation and case law. Before I present to you the course that has been developed and tell you about how we hope you would be able to use it, now, we're very happy that Mr. Mazurok remembered and mentioned this course, and those 70 judges who, thanks to cooperation with the National School of Judges, have been able to get this course, to get the certificates of the Council of Europe. It was also very important to get access to the information in Ukrainian. about the approaches of the European Court, its case law, the national law, as regards as the rights of the internal displaced person. Before I present this course to you, let me stress that the presentations that you have already seen, we already have, for example, a Ukrainian version of Lillian's presentation. We will give it another look to make sure that everything is correct there. And we would be very happy, with permission of Mr. Apostle, we hope, to share this presentation with you. Yesterday, when we talked once again to our colleagues representing the Supreme Court, with which we're organizing this event jointly, and of course that has taken us quite a lot of time to prepare it, we said that we would disseminate a package of documents including presentations, useful links and references that you have heard about today, so they can apply it in practice. So this very important presentation with the standards that have been mentioned, as well as other extremely important presentations on the European Social Charter, we will share them with you in Ukrainian. And again, let me tell you that we have already commissioned the translation of the judgment of Kandiba and others versus Ukraine that Lilian has mentioned. It's the most recent judgment of the 19th of November 2020 or 2019, because it was a judgment versus Ukraine, where Ukraine was not found to have violated its obligations. So of course, it will be translated by the Ministry of Justice. But while they do it, we hope to already have our translation on the 1st of December, so we can share it with you. This judgment is important. We will definitely discuss it in the afternoon today. And going ahead, this judgment underlines how much the courts have done for the implementation of the European standards for social security, social protection of the IDPs and people living in the temporarily in the non-controlled government territories. We will analyze those legal positions, and our experts who will speak in the afternoon will do that. And we believe that, of course, this gives us a procedural victory to the government agent, but the legal positions there are extremely useful that point to proper social protection for all the citizens of Ukraine. Okay. Again, very briefly, I hope that I will be able to share my presentation, to put it on the screen. It's always a challenge. Can you see it, Susanna? Yes, we can see it. You just have to turn on the presentation because we see the first slide. How shall I do that? Well, you're pressing the right button, I guess. No, that was the last slide, but let me get back to the beginning. Again, making it very concise for us as the biggest field office of the Council of Europe in all of the 47 member nations. For many projects, it is very important to promote dissemination of the HELP program. HELP means 4 big letters that on the one hand, if they were translated as one word, would mean assistance. But as an acronym, this is a Council of Europe program to provide human rights education for legal professionals. We're talking about a HELP platform where unified courses have been published for the judges of the member nations, for prosecutors, for defense counsels, primarily for the legal community. And these courses are implemented in cooperation primarily with the national training centers. And it's very important that these courses contain the general part, which is about the international and European standards and the case law of the European Court of Human Rights, European Social Charter, positions of the European Committee of Social Rights, and national adapted materials where every country would speak about the peculiar features of its legislation and case law. Within our project, we have focused a lot of attention during all those years on supporting the development of the course on internal displacement, which has become the first course in this area and includes now a very unique database which contains a very detailed analysis of the standards, some of which have been presented by Lillian today as regards the international human rights law, how they treat the issues of internal displacement, and very importantly, case law of the European Court of Human Rights with a very detailed review of the judgments of the European Court related to, you see, modules 3 and 4, to protection of housing, property, family rights, freedom of movement, disappearance of persons, and the obligation to look for the persons, election rights, and the issue of non-discrimination, and a separate fifth model, which is generally about social rights. Let me very briefly show you that this course is very visual, it's interesting to be taken, and its basic part has been drafted by the most renowned experts of international law, European experts dealing with the issues of internal displacement and the post-conflict regulation and the international standard.
Відповідно, бо так будуть представлені
And this is how the analysis of specific judgments will appear. There will be references. Translations of many of those judgments are available on the page of our project. And this is the second project on internal displacement and protection of IDPs. And because of that, our key mission, and even during this event, it is a key objective, is to help inform you about the availability of resources on our websites, the Council of Europe office, and international publications. We, jointly with international experts, have generated a large number of documents. So the detailed analysis of the judgments, social rights, and the key concept of Ukraine materials is to present the provisions of national legislation and cover the issues from the basic training course adapted to Ukrainian reality and to identify key problems. In the national part of the training course, we start with the concept of internal displacement. And what's very important, we will be identifying the scope of the government's commitments on European standards, the source of law, the sources of law for Ukrainian legislation. We also look in the judgments by ECHR in the cases versus Ukraine that have issues pertaining to the armed conflict in Ukraine, the loss of territory of the state over part of its territory. And then we also look into legislation, judicial practices, property rights, relations with bank and other financial institutions, the right for compensation for the lost or damaged property, election rights, right to education, non-discrimination. And we have a fourth module on social security and pensions. We adjusted and updated the national materials as of September 2020, and we introduced a separate special training course on gender aspects of internal displacement, and we introducing all the aspects to look at internal displacement through the lens of gender equality. This all is to say that hopefully you will be willing to join our course. Of course, we are ready to discuss technical issues with the Secretariat of the Supreme Court, Administrative Cassation Court. We will be very happy to continue our cooperation with the National School of Judges. But what's important, the general part of the training course in European standards, it's available for anyone. It only takes registering on the platform. And we are quite advanced, we're quite savvy in technology. So if after the event you would like to look into the standards of the Council of Europe, you'll be able to do that easily and to get access to the main part. The national materials are now closed. They are available to members of the groups. But we expect that by the end of the project, by December, we'll make the national materials open to professional communities. We'll grant access to the Supreme Court, the National School of Judges, and that concludes my presentation. We find all of that very important. This is a very important course, and we hope that you'll use the resource. And shall you have any technical issues, we are available 24/7. Thank you very much. We don't have much time for Q&A, but I think we can come back to those issues and outstanding questions during session 2. Thank you, Hannah, for your presentation. You know, I feel like enrolling in this help course. So I invite all of the judges to register there. There's no such thing as too much knowledge. Thank you very much. So going back to what's on our agenda, let me say that we have very little time, but we can take one question. But I don't see any questions in the chat, and I don't see any raised hands. Maybe these will appear while I'm talking. You can do that, but as expected, maybe we would need more effort to interpretation of the presentations, the translation of them. But what's of more interest to our participants is applying international standards in Ukraine in judicial practices of administrative courts. And we'll return to that after lunch. So we'll make sure to collect all the questions you might have had after the presentations in the first part of the day, and we'll take those questions after lunch. The second part of our webinar will be on Ukrainian context exclusively, and our national experts will present on administrative courts, judicial practices presently, how these practices can be improved, and maybe some best practices in Ukraine with regards to IDPs and other vulnerable groups of people. Thank you very much for joining the first part of the session of our event. I would like to thank our experts, Ms. Carmen Sacedo Beltran, Ms. Monica Smushkulesha, Ms. Liliana Postel, Ms. Hanna, thank you very much for your presentation. And I would also like to thank all of those who joined as participants, and I would like to invite you to come back at 2 p.m. using the same link you were sent. So please come back to have more discussions, profound and comprehensive on Ukrainian context. And all the questions that will appear after the first part of the day will be discussed after lunch. Thank you very much. It's time for a break and we'll reconvene at 2 p.m. Thank you.
Анно Бучик, я попрошу вас підключити вашу камеру та мікрофон. Анно Бучик, ви нас чуєте? Ганна, ми вас чекаємо. Вам необхідно в нижньому полі ввімкнути мікрофон та камеру.
У меня все заблокировано. Поэтому...
Ганна, ми на вас чекаємо.
Доброго дня.
Доброго дня. У вас не вимкнута камера.
У мене камера вимкнута зараз, ну, вимикнена, не включена. Я потім налаштую, включу. Я можу включити зараз.
Ну, давайте так, ми хочемо просто протестити, як це
Добре,
буде.
добре. Зараз. Добре. Так, все.
Все, чудово.
Добре, да, все. Зараз я налаштую проведення слайдів. на екрані, так? Я це повинна зробити?
Так, нам сказали, що ви хочете протестити, будучи.
Добре, зараз тоді зробимо тест. Хвилиночку. Так. Так, зараз. Я відео зараз вимкну. Так.
Так, треба спочатку
Да.
презентацію. Зараз я його завантажу спочатку. Все. В PDF.
Анна, якщо вам потрібна допомога, наші IT-спеціалісти можуть вам просто допомогти, підсказати, як і що треба робити.
Зараз. Ні, я зараз запущу на цьому.
Я їх буду власне я думаю,
А чого воно в ППТ не зробило? Навіщо PDF робити? Так, оце. Демонстрація екрану. Кажи.
Так, демонстрація екрану. Скажіть, будь ласка, все добре?
Так, презентацію видно. Спробуйте, будь ласка. Треба якось...
Я спочатку гортаю і він відкривається, якби все відбулося нормально, без проблем. Все видно, так?
Так, все видно.
Ага.
Можете лише, знаєте, натиснути іконку, розгорнути екран. Так, на цю. Це я. З правої сторони.
Так?
Так.
Угу. Все, працює. Все, я тоді, мабуть, відзвітую нашим працівникам відповідальним про те, що все добре.
Так, все. Так.
Все,
Дякую
дякую.
за тест. Все.
Да, тоді вже до зустрічі в визначений час.
До зустрічі, до побачення.
До побачення.
Шановні колеги, добрий день. В принципі, ми маємо...
Dear colleagues, good afternoon. So we have the time to start. 2 and 2 minutes. Так. Mr. Smokovich is confirming that he's hearing her. So let us start. So I shall moderate. Don't think that this is because of sexism. It is 2 o'clock, so let us start. Let us start. Dear colleagues, we are glad to see you, at least virtually. Not even the pictures, but mainly the names on the screen. I welcome all those who joined second part of our webinar, which is organized jointly with the Supreme Court, Administrative Cassation Court of Ukraine, which will discuss the social right protection of internally displaced persons and other vulnerable groups, European Social Charter and other standards, and administrative court case law in Ukraine. So we start the second session. We shall stick to the time limits. We must finish exactly 5 o'clock, and we ask all speakers to keep up to the time limit in order that later on we have time for questions and comments and discussion. Second part is devoted to domestic legislation and its application in domestic judicial practice, and we hope to hear practical recommendations. At least there will be active discussions that will be useful for practical matters. First of all, we invite esteemed Alla Fedorova, who is a national expert of the Council of Europe. Alla is a member of international pool of experts. She is associate professor and she is teaching at Institute of International Relations, Taras Shevchenko National University. Alla will speak about application of European Social Charter revised by Ukrainian courts, conclusions of the European Committee of Social Rights regarding Ukraine. Good afternoon. I want to thank organizers for the opportunity to continue analysis of European Social Charter in Ukrainian context and discuss how European Social Charter is implemented in Ukraine, and to draw attention to a very important role of Ukrainian judges in this process, which is quite important for Ukraine. Now I shall try to show you my screen and turn on my presentation and hope that I will be a success. Can you see my presentation? Yes, we can see your presentation very well. So European Social Charter is a basic European document in the sphere of protection of human rights, adopted within the framework of Council of Europe, jointly with European Convention of Human Rights. It creates the basis for entire system of protection of human rights in Council of Europe, entire European system. When talking about social rights, it's not the European Convention that all Ukrainian legal professionals and judges are very well aware. When talking about social rights, the main document is European Social Charter from 1961, which was revised in 1996. Ukraine ratified it in 2006. And it came into force from 1st of February 2007. It took 7 years Ukraine to sign it and finally ratified it. It's not such a big time, because for some countries it took 20 years, maybe 30 years to ratify it after signing. But anyway, probably this delay was connected with the fact that commitments of Ukraine were not very clearly prescribed when Ukraine joined Council of Europe. It was in 1995. And there they indicated a whole number of conventions that Ukraine must ratify. As regards European Social Charter, it was mentioned that Ukraine must start learning it with the objective of further ratification. Now, 13 years pass since European Social Charter became a part of domestic legislation of Ukraine. Out of 98 items of European Charter revised that cover all major social and labor rights, Ukraine acceded to 76 of them, first to 74, and then added 2 other clauses. As regards the article that Ukraine has not acceded, most of them are reflected in domestic legislation and in the Constitution. And when analyzing periodically articles of social charter that Ukraine has not acceded to, some articles have considerable obstacles preventing Ukraine from ratifying its suit. Up to now, you see on the slide, Ukraine has joined one item, Article 2, right to fair labor condition, annual paid leave that should last 4 weeks, not 24 days as we have. One item of Article 4, right to a fair remuneration. I shall talk about that. Ukraine has not ratified several items of Article 12, but in 2017 joined 2 of them. What else is not ratified? Article 13, right to social and medical aid. Article 19, right of labor migrants. Article 25, right to protection of laborers in case of bankruptcy of employer. And Article 31, establishing the rights accessible for low-income people. Immediately after ratification of European Social Charter, Ukraine started adopting particular documents aimed at improving implementation of the Charter in Ukraine. And one of the first documents was adoption of the action plan, how to implement it. And this action plan was approved for the period from 2007 to 2010. That happened in April, 1 month after enforcement of the article, which was very progressive. Next year, 2008, parliamentary hearings were held regarding Ukraine implementation of the commitments taken. A year later, 2009, Committee of Verkhovna Rada had a meeting discussing a report of implementation and ruled that Committee of Ministers of Ukraine didn't work properly to fulfill it. And then it was recommended to Committee of Ministers of Ukraine to implement a number of measures, to make some amendments in the legislation, and even to ratify European Social Charter in full, but only a few countries did it. What else was suggested? To join the procedure of reviewing collective complaints, because up to now Ukraine does not recognize this procedure. In 2013, in the course of parliamentary hearings, conclusions were written in a more diplomatic manner. But the conclusion was that implementation of European Social Charter was quite difficult. So unfortunately, we cannot show some dramatic positive changes. Then the next action plan was adopted for the period to 2015 to 2019. And in 2017, Ukraine acceded to other points of Article 12. In 2020, we don't have yet the next action plan. But I want to draw your attention to the recommendation provided by Committee of Parliament based on the result of the previous hearings in 2013. It was in 2013 that the recommendation was to address Supreme Court, asking them to generalize and analyze implementation of European Social Charter cases. I don't know whether analysis was done, but in 2015, such recommendations were provided. Then, what was recommended to analyze final conclusions of European Committee of Social Rights, to what extent Ukraine's situation is in compliance with the requirements, and to define specific measures that Ukraine should do to bring domestic legislation and practice to the requirements of European Social Charter. It was also provided that starting from 2014, one should organize roundtables, some activities to discuss how Ukraine is fulfilling commitments and is reporting. In 2013, it was concluded that it is necessary to publicize general conclusions of European Committee of Social Rights regarding Ukraine. Now, all these conclusions, all these recommendations provided in 2013 remain topical up to now. First time conclusions of the committee published in March were translated into Ukrainian due to the efforts of the project. Before that, not a single document was translated into Ukrainian regarding social charter matters. Now, a little bit how Ukraine was fulfilling commitments taken. In 2011, up to 2013, many issues were not included in the national report. Therefore, Committee on Social Rights, in its conclusion, noted that 67% of ratified provisions of the Charter required additional information. The committee could not make its conclusion because information was not provided by Ukraine. In the course of all previous periods, all years that Ukraine is submitting reports how it implements social charter, and committee is providing its conclusions, Ukraine is not reaching even 50% of fulfilling its implementation. In 2013, a little bit less than 20% were implemented. In general, I must say that all cycles of reporting is divided into 4 years period. Each year, a country is providing a part of report on particular topic. On this slide, you can see the statistics. Entire cycle of implementation provided by European Committee of Social Rights. 2016, out of 24 provisions reviewed, only 2 were in compliance with the requirements of the Charter. In 2017, 1 positive conclusions only. In 2018, that was the cycle regarding labor rights. Ukraine has fulfilled biggest number of commitments, 9 positive conclusions out of 21 items reviewed. And then, as you see on the slide, situation is not much better now. And now in 2019, last year, as regards children, families, and migrants, Ukraine fulfilled positively only 7 situations. Now, a few words about most recent report of Ukraine. And then a little comparative analysis. Which recommendations were provided to Ukraine earlier in 2015, which we have in 2019, that we could see that very often the European Committee of Social Rights concludes the same problem is available in Ukraine, or providing same recommendation, maybe writing them in more details. In 2019, recommendations from 2019, out of 7 situations that were assessed positively, none of the particular articles were assessed as positive. Positive assessment was regarding only some items or particular articles. Article 7, only couple of items are assessed positively regarding labor rights of children and adolescents. Ukraine have not fulfilled its commitment regarding minimal age of employment and engagement of children to labor. Light work. And the committee already emphasized that it needs more clear definition of what is light work. There is no definition until now. Work of children under 15 in cinema and content industry. The conclusion of committee was that more than 600,000 children from 5 to 17 are working in Ukraine. When providing other examples in comparative aspect, we can review Article 31. Promoting access to housing. Right to adequate housing is not guaranteed. Before obtaining this information, well, conclusion remained the same.
By the way, with regard to the same article, there are some additional reports. We will get back to them later. Talking about point 2, that's prevention of homeless status, you can see that the opinions are always almost the same. And item 3 has not been ratified by Ukraine. Plus, we cannot help but mentioning another article of the European Charter, which is the right to health care. I think that this article is probably one of the most basic ones. This right to health care is provided by Article 11 of European Charter, contains 3 items or 3 aspects which should be taken into consideration. So first, in order to ensure this right to healthcare, the parties must take certain measures. First, remove the reasons for poor health condition. Life expectancy in Ukraine is 71, which is much smaller than in Europe. So Ukrainian legislation does not comply with the charter requirements. We have high rates of children mortality, insufficient measures to ensure access. Another point which seems to be simpler to execute, which is about consultation and education. Here the European Committee also found that the preventive measures through screening are not used in Ukraine as a contribution to improve the health condition of the public. In addition, it was found out that there is a need to increase the awareness of the public with regard to their own health. Item 3 of this article is about prevention to the extent possible of epidemic, endemic, and sicknesses. So here again, it was stated we do not ensure sufficient immunization, nor we do sufficient monitoring. Plus, the European Committee draws attention to such problems as abuse of alcohol, tobacco, and even advertising of alcohol and tobacco as obstacles towards compliance by Ukraine of with this specific obligation concerning their right to health care. Before I will switch to the actual analysis of the case law of application of European Social Charter by Ukrainian domestic courts, I'd like to stress that in my presentation, I will talk in depth about some points. First of all, we'll talk about the way the Ukrainian judges use the European Social Charter, and then depending on how much time I have, we will get back to the practice of European Committee for Social Rights, because the European Charter as well as European Convention is a live document, and it is implemented through the practice. So far, we've examined the statistics and decisions or judgments that can be found in the Unified Register of Judgments of Ukraine, and we found references to 100 provisions, which means that Ukrainian judges do apply the European Social Charter, and this trend is growing starting from 2019, 1920, plus they refer more and more into to European Social Charter in the determinations of administrative courts, which is a very positive phenomenon. But unfortunately, there are no changes in the trends that we would like to see. What are the typical types of application of European Charter by Ukrainian courts and how they apply the provisions of the Charter? And then I'll give you some specific examples. First of all, it would really be great to have more judgments where they refer to very specific articles, ratified articles of the Charter, or maybe to the principles of the Part 1 of the European Social Charter. Of course, you can find such judgments in the case law, but if we talk about references to specific points of the Charter, you won't find many. Also, the European Social Charter is mentioned as part of the list of other international legal documents of the universal nature, including Universal Declaration of Human Rights, International Pact on Social Rights. By the way, it looks very similar to the examples provided by Monica with regard to the case law of Polish courts, where the European Social Charter is taken as the basis for a judgment, as well, similarly to any other international instruments. Also, we can find references to specific points and articles of the Charter which have not been ratified by Ukraine. You can find cases of this kind in 2009 or 10, when Ukraine did not ratify the Charter yet. I think the simplest option for judges, and we can find most of the examples of this today, is when they refer to specific items of the part 1 of the Charter instead of referring to very specific points of the articles of the Charter. Unfortunately, I even made it in red color that among all the judgments, the references to the practice of the European Committee for Social Rights have never been used. And I can tell you right away that for Ukraine, it's a very regular phenomenon. We say that not all of the European court judgments are translated, and it's difficult for the judges to use them. But here the situation is different. No, you will never be able to find any decision of European Committee translated in Ukrainian. You will not find any general recommendations. The only document that you would find is the opinions of 2019. Let me give you some more examples where the judges refer to the ratified articles. This is about judgments delivered by the district court in the first years after the ratification of the Charter. For instance, this is a judgment to collect fees for the centralized heat system. The judge mentioned the international acts ratified by Ukraine, including the Charter, European Convention of Human Rights, and European Social Charter. In addition, the judge drew attention to the Article 12 of the European Charter, although at the same time, Article 12 at that point of time was not fully ratified by Ukraine as the binding article. In 2010, there was another judgment of a district court concerning rejection by the authorities to pay monthly subsistence or financial assistance to an individual. And again, there is a reference to the Social Charter, Constitution of Ukraine, and to the law of Ukraine and execution of judgments of European courts. So these judgments should be viewed as very positive phenomenon, showing the interest of the judges with regard to the European Charter. But before this current project of the Council of Europe was initiated, very little attention was paid to that. There were no webinars or seminars for judges. How would the Ukrainian overloaded judges find the time to learn that Ukraine ratified Article 14, but ratified Article 12 only partially, while Article 13 was not ratified by Ukraine? It's very difficult for them, especially since they do not have any special training courses on protection of human rights in the light of European Charter. By the way, international experts paid attention to the need to train judges in the matters of European Social Charter. Now we are almost completing the analysis of the curricula for teaching the Social Charter at the universities, but before that, there were no training courses at all devoted to this document. Some other examples were some specific points of the part 1 are referred to. This part one, contains the principles, general principles. So many cases of this kind, you can see the examples on the slide. Judgment as of 2019-20. The judges refer in their judgments intention disputes to the part one of the charter, which provides for general rights and principles. If you open the charter, you'll see that after the preamble, part one starts with the wording that the parties recognize the goal of their policy, achievement of conditions which will ensure effective implementation of the rights and principles established in the part one. And then all these principles are detailed in the part two of the charter. So one of the principles is that in 2019 there was a judgment of the Supreme Court where the defendant was found guilty of failure to pay a pension to the individual who took part in the anti-terrorist operation. He was on the territory of the operation and couldn't leave the area because of the age and the health condition. So there was a reference to the European Social Charter, to the right of any individual to the social protection, and here they used this provision concerning Ukraine undertaking obligation to make everything possible to ensure conditions where the implementation of the charter is possible. So here we can say that, of course, it would have more weight if they refer to a specific item of the Article 23. But here we can say that the Ukrainian judges may even end up in a more complicated situation, because if they refer to a specific item of an article, they need to pay attention to the interpretation provided by the European Social Committee to this specific article. I'll give you some examples of such interpretation about the right of the older people to the social protection. The country undertakes to take specific measure to provide to the older people an opportunity to remain as long as possible full members of the society. Providing sufficient resources, that's questionable term, and second, through information on services and programs available to the older people and the way they can use or subscribe to such programs. So when they talk about programs and services, they talk about providing information to the individuals of the age. But the committee stressed that it's about the volume, payments, fees collected for participation, and that in their opinion, with regard to France, yet in 2002, the committee confirmed the obligation of the countries not only to provide sufficient information, but also, in spite of absence of direct existence of such services, the state is under the obligation to provide obligation concerning availability and cost of the services aimed at ensuring the rights of older people. Otherwise, the committee states the country will be in violation, breach of Article 23 of the Social Charter, although the Charter does not have direct provision of this kind. Plus, the committee also made a recommendation concerning ill treatment of older people, which includes the increase of their awareness of their opportunities, etc. And the committee stated that it will not provide for an independent definition of this provision, but the definition to be considered is the one suggested on Toronto Declaration concerning the ill treatment of of older people. And actually, in the opinion with regard to Andorra in 2008, this definition was used. Certainly, if we are talking about the ill treatment, so then we'll immediately have association with Article 3 of the European Convention, but it's clear that it's not about representatives of the state. Another interesting example can be when the judges refer to several principles at a time from the Part 1 of European Social Charter, especially when one article has been ratified by Ukraine and the other one has not. Say the Supreme Court referred to point 4 and point 23 of the European Social Charter. And actually, that's where we can say that that was kind of a symbiosis of this combination of ratified and non-ratified provisions. Indeed, the right to fair remuneration, which is point 4, provides for the right of employees to the fair remuneration, ensuring sufficient level of the life for them and for their families. Ukraine did not undertake to comply with this requirement, and later on the Committee for Social Rights interpreted what they mean by sufficient level of life. By the way, I couldn't find any other interpretation of this point by any other international authorities. The committee found that such remuneration should constitute 60% of the minimal wages, meaning that, I mean, the average wages. So then the state may say that if the payment or the remuneration is for 50 to 60% of the average salaries, then the state may say that they do sufficient, they're doing good enough to comply with this provision. If not, then, well, this is a kind of a direct, strict mathematical formula which actually fails to take into account the specifics of each country, but this is what we call minimal standards of European Social Charter. Some more examples of the case law, some references to very specific items and specific articles of the European Social Charter, where I already mentioned the determination of the Supreme Court 2017, when the discussion was about the labor laws, and the judges referred to the International Convention of the International Labor Organization, and they also referred to social charter, talking about the lawfulness of dismissing or firing an individual. Also, I would mention the judgment of Constitutional Court of Ukraine of 2018, where they referred to the European Social Charter and to point 3 of the article. In 2017, Ukraine ratified this point. In 2018, they referred to Article 3, Item 3 of the Article 12 of the Social Charter in the matters which are very relevant up to now, where they talked about references to current practices.
Last example, decision of the Administrative Court from 2010. The action was unlawful and the person was recognized as combatant. The complainant, in his argument, asserted that Ukraine has violated Article 12 of European Social Charter. Judges, on the other hand, viewed Article 12 since Ukraine ratified European Social Charter. with exceptions. Article 12 was not ratified, and since complainant referred to Article 12, it could not be the argument. Ukraine has not taken international commitments based on this article, and it must not be applied in this case. I think that with that, I can finish my presentation. I can only repeat once again that it was not possible to find references to the cases of European Committee of Social Rights in the caseload in the judgment of Ukraine Administrative Court. Number of references to Ukrainian social charter is growing, and we would like to see this trend continue. As regards protection of social rights, very often Ukrainian judges refer to case law of European Court of Human Rights, but we must remember that European Social Charter is a specialized document that covers a broader range of social and labor rights. Due to the legal positions and interpretations that European Committee of Social Rights provides. And when emphasizes that European Social Charter is the same living instrument as European Convention of Human Rights, I will come to other parts of my presentation. Concrete examples from the case law of European Committee of Social Rights for us to see how broadly European Committee of Social Rights is interpreting European Social Charter. My approach is not very optimistic. I don't think tomorrow the law will be adopted that will make a parallel between the case law of European Committee of Social Rights and European Social Charter. But European Committee of Social Rights is interpreting the provisions of the Charter, and Ukrainian judges must take into account not only conclusions of the committee regarding Ukraine, but entire case law of the European Committee of Social Rights. And judges must refer to that, take into account all articles of European Social Charter. That's what Susanna was talking about. As regards European Social Charter, we are now at the stage at which we were before 2008, when the law was adopted on application of the case law of European Court of Human Rights. This article is a good example of general formulation and broad interpretation by committee, full sense. Article 31, right to adequate housing. It is short. It contains 3 short items, which are obligations of the state to promote access to adequate housing, to prevent homelessness, and item 3, establishment of prices for housing affordable for low-income persons. But Ukraine has not ratified item 3 of this article. That means that the state has positive obligations in the context of Article 31. And in the judgment versus France, the committee said to achieve stable progress on attaining the goals established in the Charter, you should not only take into account the legal means, but availability of actual resources and application of actual procedures. When the right is complicated, especially from financial point of view, to be implemented by the state, participating countries must take measures within reasonable time with particular progress, using existing resources to the maximum possible extent. So in this case, the state should have paid attention to the fact that the most vulnerable groups of persons, in the French case, were the persons who were below subsistence level and they were not provided housing. I will come to cases and conclusions of European Committee regarding internally displaced persons. The committee asked Ukraine to provide explanation which percentage of IDP is provided houses, because Ukraine wrote that only 7% of IDPs live in the housing provided by Ukraine. In 2019, the committee got interested of that and put a particular question to Ukraine. Possibly in the next conclusion, committee will express bigger concern regarding this statistic. And the main thing, when talking about obligation of Ukraine that it took regarding promoting access to adequate houses. If a Ukrainian judge is refers to item 1 of this article, the first question will be, what is it an adequate housing? Because in the text of the Article 31, nothing is told about that. But in conclusion, from 2003, in the case versus France, committee clearly interpreted that concept of adequate housing must be defined in domestic legislation. And Leicester said, what is it an adequate proper housing? 3 things. This housing must be safe from all points of view, starting from sanitary conditions, heating, and ending with the reliable construction of the house. Then, this housing should not be overcrowded. There are certain standards, how many persons should live, how many square meters per person. And third issue that committee focused attention on, this housing must be in condition of safe possession. In conclusion, regarding Ukraine, committee paid attention to quite traditional thing. Definition of housing of adequate quality must pertain not only to the newly constructed houses, but gradually use regarding existing housing assets. And new legislation was adopted in Ukraine in 2006. Then committee asked, houses constructed before 2006, do they comply with this criteria or not, and who is verifying that? Other examples regarding rights of internally displaced persons. European Committee of Social Rights reviewed the case Center of Housing Rights and Eviction of Persons in 2010. This decision was taken. The facts of the case are on the slide. Before the war in former Yugoslavia, before Croatia became independent state, housing was provided not for rent, but just for use. And those who legally dwelled in those houses had no possibility to sell it or to come into ownership title, and it could not be inherited. And in this case, great number of persons, mainly ethnic Serbs, were forced to abandon these houses. And they asserted that Croatia is to blame for violating Article 16 of European Social Charter, family protection, social and economic protection of families. When reviewing this case, European Social Committee looked at very important things. The family is a big group of IDPs affected by the situation. And second, what was interesting, that among arguments provided, there were such that pertained to terms who stayed and who are not going to come back to Croatia, and those who were willing to come back to Croatia and to get their housing. Committee said it will not review the situation regarding moved families that do not plan to come back to Croatia. Then the committee said all those delays and uncertainty regarding implementation of housing programs since 2003 until 2010, 7 years passed. Now it's already 6 years of the conflict in Ukraine. European Committee ruled that this period, this length, was unreasonable from the point of view of requirements of European Social Charter. And they ruled that Article 16 of European Social Charter was violated. Then I want to mention 2 decisions against Finland. The committee made these decisions based on the procedure of reviewing collective complaints. Ukraine has not adopted it yet. The national expert mentioned it several times, referring to this judgment against Finland. And Monica said that Polish court referred to this judgment against Finland. This Finnish community of social rights is very active and permanently addressing committee with complaints quite successfully, trying to protect social rights of the Finns. In 2019, a new complaint was adopted regarding a reduction of level of social benefit in connection with economic situation in Finland. So in Finland, it looks like economic situation is not very good. What the claimants drew attention to in the period from 2015 to 2019, social benefits were reduced, and all that impacted and worsened situation of vulnerable groups of people. The government denied that. But what committee ruled? They said the objective of reviewing collective complaints is different than reviewing of the report of the government. Legal assessment of the situation in the country made by the committee, taking into account information provided by the claimant, and the adversarial procedure will be very different from simple analysis of report of the state. And the fact the state had already provided report on that, or is going to provide next report, it is not important for European Committee of Social Rights. This application was recognized acceptable. When talking about case law of European Committee of Social Rights, important is to understand the structure of the decisions of European Committee. In their decisions, same as in judgment of European Court, they make analysis of a particular issue, analysis of all international standards, universal standards, and European standards. And European Committee very often refers to the case law of European Court of Human Rights, even to legislation of EU. Having the possibility to know what was the decision of European Committee of Social Rights, Ukrainian judge could have all possibilities to use it. My time is finishing, so I'll be very brief. I should probably ask moderator to give me additional 2 minutes to make the final conclusion. In 2014, a decision against Finland was taken. So the facts regarding reduction of social benefits and social protection of the Finns, European Committee of Social Rights interpreted universal standards very broadly and indicated that reduction of financial help to students could not be viewed as payment from the system of social insurance. Then they mentioned this social insurance must cover a considerable part of the population, how it should be financed at the expense of the employers, employee, and the state. But when this system is paid from taxes, then principle of equality was emphasized to get this help. And the European Committee of Social Rights once again clearly formulated its position regarding proportion between the previous income and the payment from social protection system that person will get. This payment should not be less than 50% of the average income that that person got. In our Ukrainian legislation, it's also mentioned in some documents, Cabinet of Ministers, when payment is less than 50%, the committee can take into account some additional payments that could be made. This is the basic difference. Our system of social protection is confused. It's multiple. We have great number of additions, benefits, helps. And the European Committee of Social Rights says if a person gets from 40 to 50% of the main benefit, main payment, then committee can take into account other benefits for traveling, for housing. But if the main benefit is less than 40%, all other benefits, payments, additions, compensations are not taken into account by committee. They calculated the pension, 763 euro, minimal one, is 38% of this medial equivalent income. And accordingly, committee ruled that this is a direct violation of Part 1 of Article 12 of European Convention, 38% of the previous income. I shall not even make comparison with Ukraine. And the last decision that will ask Suzanne to translate. It is a decision from 2012. Change of social legislation, cancellation of certain payments, certain benefits, Easter bonuses, bonuses for days off were reduced for pensioners whose pension was less than 2,500 euro, including all additions and payments. They analyzed the case law of European Court and ruled how you can decide whether certain limitations are in compliance with European Social Charter. There are 3 requirements that should be taken into account in order that these legislative reductions are in compliance with requirements of European Social Charter. I have used all my time, so I come to conclusions. I can say that despite reduction of references by Ukrainian judges to European Social Charter, this document remains still as the source of law. This case law is not used, but it would be very good that the judges know it. But it should be translated, and it would be good in order to move it. Thank you very much, and sorry for taking too much of your time.
Дякую, шановна пані Алло. Ви практично з британською точністю завершили у...
Yes, thank you very much. Indeed, you finished at 3 sharp. We really appreciate this very punctual approach. And of course, all information that you shared with us certainly is very helpful and useful for both judges and others who deal with the law. Just some points, and then we'll go to the next presentation. First, I need to say that the judgment as of 2010 about eviction of IDP in Croatia was translated, but that's confirmation of your words that probably there wasn't proper interest with regard to the practice of the European Committee, although that decision was even placed on the website. So this coordination with regard to implementation of the European Social Charter actually becomes more and more popular among the public. And I hope this translation of the committee's decision will be useful for our users. Another point, I just like to draw attention to the fact that what we're discussing is first of all about administrative justice, because European social charter, in contrast to European Convention, is built as a list of obligations undertaken by states. And any obligation of a state is something that refers to all branches of powers, and the European Court stated very directly that any obligations of a state cannot be imposed on only one branch of power. This is a team game where legislator create legislations, the executive provide budget to implement, and the judiciary then monitors the compliance with the legislation according to the European standards. And the question to what extent the state complies with its obligation is subject to review by the administrative courts, means that the awareness and knowledge about the European Charter I mean, whether the state complies with this charter, this is a responsibility imposed on the shoulders of the administrative jurisdiction. One more important point for us, feedback is a priority. I mean, feedback with the 14 individuals that we can see here in the list of our participants. Of course, this kind of format prevents us from full-size interactive communication, but we'd like to stress that thanks to this very careful preparatory work conducted by the Secretariat of Administrative Constitutional Chamber, the preliminary questions were sent out to potential participants, and we received some feedback with regard to some questions that were asked in advance. So we are ready to actually mention these comments when discussing the answers. Now I'm going to read the full list. The questions were about pensions for IDP, people coming from Crimea, the extent of protection of the rights of IDPs, more specific questions about payment of pensions, protections of property rights, exercising of property title by IDPs. There was a separate question about the margin of discretion by the courts. So for further speakers, you are kindly asked to refer to the questions that were asked in advance if you have any comments in that regard. I will conclude by saying that we have questions and answers title, you can write there, push that button. Now that's a chat for discussion, which is translated into English so that the foreign experts can participate. It's about the quarantine period where the government decided not to suspend any payments of the pensions to IDPs in spite of the difficulties that are linked to the quarantine in obtaining proper documents, confirmation certificates of residence, etc. Another question is how well we are aware of experience of other countries. Here, I'd like to ask you to use the presentation by Apostle, Liliana Apostle, where you can find experience of Moldova, Georgia, Balkan countries, Azerbaijan, how they ensure the social protection of the IDPs, even to migrating individuals who continuously come and go from the government-controlled territories. This experience has already been presented in the presentation. Once again, by the end of this week, we undertake to finalize this presentation and make it available for you. And now we are moving to extremely important presentation by esteemed Justice of Cassation Administrative Court and Composition of the Supreme Court, Mrs. Anya Buchik, who will present us the case law of the Supreme Court with regard to the protection of social rights of IDPs, internally displaced persons. Good afternoon, everybody. Good afternoon, esteemed hosts, organizers of the event, participants, esteemed colleagues. I'm really pleased to take part in this event. Indeed, that's a big honor for me to make a presentation for you representing the Supreme Court, especially the Cassation Administrative Chamber of the Supreme Court. And the subject matter for today is the case law of the Supreme Court in protection of social rights of IDPs. So I'd like to clarify some technicalities. I hope you can all see the slides. So I'd like to note that in general, the internally displaced persons is a specific category of the population which has been dealt with by the global communities for a number of years, but for the Ukraine, it's for the first time during its history. I mean, the latest, of course, the latest years, and that's where this legal phenomenon appeared. The essence is that these are the citizens who, because of the warfare and negative impact of the warfare, were forced to leave the domiciled their continuous residence in order to save their lives without crossing their national borders. The legal status of such individual was defined by the parliament, by the law, as of 2014 on ensuring rights and freedoms of IDPs. There's the document which defines both legal status of the IDPs as well as the economic, social, and legal guarantees the protection of their rights on the territory of Ukraine according to the Constitution of Ukraine, international agreements, and provisions of the international law. According to provisions of Article 4 of this law 1706, the fact of internal displacement is confirmed by a certificate on registration of an IDP by a respective public authority. So it's a special law on ensuring rights and liberties of the IDPs, which regulates the legal relations between the state and these individuals. And also there are some other laws which are evoked. This is about the freedom of movement of Ukraine, residential housing of social purposes, the non-Ukrainian single state demographic register and document confirming the citizenship of Ukraine, and the law of Ukraine on ensuring rights and freedoms of the citizens and legal regime on the territory of the temporarily occupied territories of Ukraine. I'd like to mention right away that one of the questions asked in advance was about the status of the individuals who were forced to leave the Autonomous Republic of Crimea. In fact, their legal status is regulated by all these laws, including the last one mentioned on this slide, but we don't have any respective case law in our court. Maybe trial courts or courts of appeal have dealt with this matter, but it's not really it's not the case as you see often. In addition to the laws regulating the status and the matters of protection of the rights of IDPs, there is a number of secondary legislation acts. This is what you can see on the slide, this resolution of the Cabinet of Ministers of Ukraine on approval of certain procedures aimed at regulating these legal relations with the state and also aimed at the implementation of the legal provisions that have been declared by the legislation. The cases where these laws were used, including the target assistance to the IDPs, about issues of respective certificates to confirm the status of an IDP. So during the court practice, there were some obstacles in protection of IDPs' rights, and they were forced actually to apply with the courts, and it's only then they were fully satisfied with protection of, their rights was fully satisfied because some of the regulations that you can see on the slide, in some of their points might be contradictory to the legislation that was adopted with this respect. Overall, this category of individuals appeared, and since this respective category of cases appeared, and the State Court Administration of Ukraine issued the order number 622 in 2018, and it actually became effective since 2019, 1st January. So by this order, this subcategory of cases related to IDPs was specified as a separate subcategory with application of respective classification codes. And you can see this correlation between the codification and the names of the specific case, of the essence of a case. Respectively, The next slide depicting the information on the number of applications with administrative courts related to IDPs. You can see that the biggest portion of the cases that have been considered falls on 2019. And in fact, the statistical analysis shows that the courts in most of the cases related to protection of the rights of IDPs satisfied the requirements or the claims by IDPs, but there were some judicial mistakes in application of the legislation that regulates the resolution of such disputes, but these errors were really minor and were corrected later on. During 2019 and 20, since till November, the administrative court of cassation appeals, as you can see, revised 125 judgments. So you can see all these matters were very relevant for the period of time, and as you can see, the case law had very positive impact over regulation of some doubtful aspects of the legislation, and the Supreme Court clearly stated its position, which certainly helps now the administrative authority to make proper respective decisions. Next slide, this is about categories of disputes arising from the matters of protection of IDPs' rights. So what the courts have to deal with, these are cases about registration of an individual as IDP with issuance of the respective certificate, because the certificate constitutes grounds for all other payments from the state. Then the cases concerning the reinstatement of the pensions and entitlements, ordering the monthly targeted ad hoc financial assistance, payment, and other kinds of payments. So as you can see, most of the cases deal with the actually financial support to these IDPs. Also, we can look at further details, and we could look at each category separately as the right to be registered and receive the respective certificate. These disputes used to be between the natural persons and social protection public authorities, and the reasons to refuse the application for registration was the lack of identification documents, lack of documents confirming loss of residence on the territory from where the individual comes, a lack of documents confirming the fact of being a resident of this territory, and confirming the circumstances which caused this displacement, or maybe the town or village where the IDP comes from is not included into the list of respective towns and villages which were identified by the respective resolution of the Cabinet of Ministers, which clearly identified the settlements from where the citizens were supposed to become an IDPs.
Через порушення фізичними особами.
Other reason. Alleged violation of the procedure of getting certificate of IDP status when not IDP himself or herself addressed in person, but sent by post. Such group of cases were reviewed by Cassation Administrative Court positively. The argument was that the basis for registration as an IDP was the circumstances that caused this status because of the negative consequences of armed conflict. And the fact that a person left hostilities play to avoid negative consequences and has characteristics of an IDP. As an argument could be information from official website of OSCE monitoring mission that the armament and military equipment was noticed near the village where that person dwelled. The court also believed that if we compare the resolution of government and the list of villages and settlements which are not under control of the government, the latter had a bigger force. And if the person didn't provide that, could not be the reason for refusal of issuing the status. If it is known that the former place of residence of that person is temporarily occupied, a legislator requires presence in person at the moment of issuing IDP status, and the court confirmed this requirement. Next, as regards payment of pension to IDPs. As regards the dispute mentioned, a pilot case was mentioned by Cassation Administrative Court on that. That model case had an applicant, a pensioner, who was receiving pension by age. He left his permanent place of residence because of military hostilities. He left the village where he resided permanently previously. Supreme Court, in the mentioned case, referred to European Social Charter, take into account the fact that Ukraine took international commitment to ensure effective observance of the rights specified by the pension. Issuance of pension is a constitutional right of a person which is guaranteed by international commitments of Ukraine. Non-confirmation of the place of residence is not a legal ground for non-paying pension, and Cabinet of Ministers of Ukraine, in its resolution from 8th of June 2016, number 365, on certain issues pertaining to paying social benefits to IDP, is only a bylaw. which, in the view of Supreme Court, limits the right established by the law to get pension by an applicant. Now, cases regarding renewal of paying pension or paying pension. The next slide. We also had such cases and in the case law of Supreme Court. And the court ruled that the state defined the mechanism how to renew pension rights of the person residing on the territory not controlled by government of Ukraine. The person should make particular steps to move to the villages or towns which are under government control to get a certificate that he or she is an IDP, and personally or through his authorized person to apply to pension fund to renew paying his pension. Also, in practice, there were cases of payment pension by age on beneficial grounds. The court used Namibian exceptions defined by International United Nations Court. They took into account the arguments of the document issued by the authorities in the territory of anti-terrorist operation, because their non-acceptance would be the violation of rights of the person who had been working previously in the conditions hazardous for their health. At the next slide, you can see cases regarding renewal payment of pension to IDPs. Then cases regarding paying monthly monetary benefit for payment for housing, in compensation of payment for housing and paying utilities. Such cases were in cases when applicant went to court asking to get this payment to cover housing expensing and payment utilities. One of the requirements was to oblige state authorities to make such payments. In this group of cases, what was important? One of the components of requirements was to provide a package of documents. Among them, the information about previous employment. And the payment was connected with 6 months period. The court believed that in case a person of labor age could not find a work, payment for unemployment is provided for 6 months. But the person cannot be, and the person cannot be deprived of this benefit within the mentioned 6 months period. I see that my time is finishing, so I shall try to conclude as quickly as possible. I will show you slide 13, the right to pay the pension in other benefits to other groups of persons. They're very important because it is the benefit provided to pregnant women or at birth of a child or a person lost ability to work. Children with disability, to families that are in dire living conditions. So the references were made to case law of Supreme Court. which is quite real. We had a number of such cases, so as soon as the judgments are made, we shall publicize them. It will be on our website, and you can get to know our case law in more detail. Slide 14, cases regarding allocation and accrual of other benefits to internally displaced persons. You see reference to the resolutions of Supreme Court in this group of cases. I will not speak in detail about that. I can present you a document review of case law of Supreme Court in the sphere of protection of social rights of internally displaced persons and case law regarding application of European Social Charter revised. Cassation Administrative Court is presenting this document. You will have the possibility to get familiarized with this document and learn the cases mentioned there. Since time is limited, if you have questions, I can provide you answers in the chat, at least some of them. There was a question regarding rights of internally displaced persons, how to protect them. My presentation was just based on that. Judicial control is a very effective mechanism of protecting rights of internally displaced persons. Judicial procedure for reviewing such disputes is clear, and it allows to work effectively in this sphere and use case law. This case law could be used both by the persons who have this status and by state authorities that base their work on legislation. This is briefly all. My time is finishing. Therefore, I want to thank participants of the conference, all listeners, presenters, and organizers that were engaged in discussion of this topic, which is both important and topical and need be discussed. So thank you all for your contribution and for the work on this subject and for implementation of such important issues into life. Thank you, esteemed Anna. Very specific presentation. So you can provide this to us and we can share it with participants. Yes, this is the review. This document is a review of our case law. It contains information that I personally used when preparing for my presentation. And my slides, my presentation could be freely used for sharing or for publicizing. You can share it with participants, organizers know that. I am ready to share it in the format required by technical rules. Thank you. It would be very useful to us. From our side, we confirm that this review of case law Supreme Court is in free access on the website of Supreme Court. For us, it was very important to see it. This is a very quick movement forward when judicial branch took entire burden of commitments to protect rights of people, internally displaced person, entire scope of European standard. I want to make a brief comment. Our first project was protection of human rights of internally displaced persons. And at the beginning of the project, our dear colleagues, our national partners, asked us to remove these rights, human rights of internally displaced persons, just to say rights of internally displaced persons. But we emphasize that human rights of IDPs is very important. That emphasizes that we are talking about fundamental rights of persons, of a particular group of persons who are IDPs. That means that entire scope of international commitments of the state is covering them, and European standards of protection of human rights. What important to stress it. Anna, there is a question to you, which is connected to the previous, but it's a very concrete question. Question to Anna Buchik, how to protect social rights of persons who have not displaced from occupied territory and don't have a certificate of IDP, which authorities they should address to get pension, to get birth certificate or others benefits, and 3 question marks showing how important it is. Please, your comment. Thank you for this question. I understand that listeners want to know what to do if a person de jure remains a citizen of Ukraine, has a passport of citizen of Ukraine, but still resides on temporarily occupied territory, which is not under government control of Ukraine, who has no access to any resources of the state resources. I would like to mention that such person, in any case, even according to the case law of Supreme Court that we have, that person has the right for social protection from state of Ukraine. But state of Ukraine cannot cover with its social protection a person which does not make any steps when that person doesn't provide information of that person. If that is passive behavior, that person resides in the occupied territory and the state does not know about that person, that person was entitled to get something and was in the database. There is some information. But if just that person acquired pension age and acquired the right to get the pension, it would be reasonable for that person to be active, to show active behavior. State of Ukraine, particular institutions responsible for that, do not refuse that person if there are reasonable grounds. But in order that that person is covered by these rights, that person should apply for that. This is my personal vision of this problem. As regards this particular thing, maybe I didn't understand your question correctly, how it was formulated, then please specify it. Maybe give me a hint.
Чітко сформульовано питання, до яких органів їм треба звертатися за отриманням пенсії, допомоги.
Yes, there were questions about the specific public authority which should be contacted if, say, a child was born, meaning public authorities of Ukraine, which are not located on the controlled territory. So now there is a specification. What if, in view of the age or health condition, such individual cannot visit the respective public authorities on the territory of Ukraine? Well, the individual can empower another individual to act on his or her behalf, including exercising their rights. And that is absolutely acceptable if there is a force majeure status which prevents an individual from acting directly in person. So I think if there is a will, there is a way. I mean, one needs to contact the respective competent authorities to protect his or her rights, because dormant right is not subject to protection. An individual at least has to claim his or her rights in any way available to such individual. Thank you. Very clear position, very clearly articulated position. Yes, I read Alyssa says thank you, which means that she received the answer in spite even of this online format. So as you can see, everything is possible. As far as the answer is concerned, it's indeed on the subject matter. And since we are moving to the next presentation, probably we'll hear some very specific examples about the individuals who chose not to keep silent, but to address the competent authorities, even looking for legal remedies through the courts. So thank you very much. I hope you'll stay with us. We'll have some summarizing comments. We'll still probably have some time later on the questions and answers. So, esteemed participants, please stay with us. Write your questions and we'll ask for answers. So, we already heard about this summary opinion of the Supreme Court, and Julia Trala, who helps us with the implementation of this Council of Europe project, who is a coordinator in the area of legal protection of a well-known foundation right to remedy, which is very famous among the IDPs. And I'm inviting Julia to present the national case law, domestic case law, through application of standards of the Council of Europe. This is already the third edition of this the book, and that's where they analyze how successfully the judges apply the standards of Council of Europe to solve to decide on specific cases. And maybe we'll hear from Julia the analysis of well-known case, Kandiba and others versus Ukraine. Please, Julia, the floor is yours. Yes, good afternoon. Esteemed participants, let me just adjust my presentation. We can see your presentation, just make it full screen. We can see your presentation. Perfect. Yes, we can see now full screen presentation. But we cannot hear you though. So now it's all right. I hope. I did a lot of training, but unfortunately I wasn't successful from the first attempt. So thank you for the opportunity to take part in this event in line with both projects of the Council of Europe office, being also co-author of this handbook on the case law with regard to IDPs. It will be the third re-edition, because every
апеляційної інстанції продукують нові рішення, нові правові позиції.
Deliver judgments expressing their legal positions, thus reforming the case law in various matters. This year was also very fruitful. And if we get back to the previous question, that's exactly where the
Якщо говорити про
in a number of cases.
сам посібник, я не буду
So talking about the handbook, I won't tell a lot about it. It includes a huge amount of judgments and social entitlements. That's, of course,
переселенці, люди, які постраждали від конфликту.
for most of the IDPs and victims of conflicts. Another block of cases is about compensations of material damages, residential damages. Also, certainly, that's about non-material damages, intangible property, etc. So, to a big extent, this handbook is pinpointed with the judgments of the Supreme Court and the chambers of the Supreme Court, but there is a number of examples of the case law of the trial courts and courts of appeal, because in some areas the cases have not reached the Supreme Court yet. Maybe they will never get there because the proper solutions will be found by the lower courts. So in view of the questions that we've already heard, and also in view of the fact that this handbook is designed at monitoring the trends, I would say, to monitor the trends for compliance with the Council of Europe standards, I'd like to make more detailed points about the case law of European Court with regard to the armed conflict in Ukraine. And also I would refer a few points to social area. So at currently the European Court case law is not large. And I wouldn't say it's kind of laying some foundations. For me, important cases are like Caesar and others versus Ukraine. The judgment passed in February 2018, and that's where the applicants were the individuals entitled to pensions who live and temporarily occupied territories. The complaint was about the violation of their property right, access to justice, and discrimination. These complaints were dismissed and found unadmissible because actually the applicants failed to look for remedies at the level of their domestic judicial system. Another case that was decided actually last year, that's a case condemned by others versus Ukraine, when mass media stated once again about the victory. And this was again the case about deprivation of social and pension entitlements of those who live on the temporarily occupied territories. But the difference with the first case consists in that the applicants tried to use domestic remedies to protect their rights. And the peculiarity of their situation was that they used the collective claim rather than individual claims to challenge specific provisions of the resolution of the Cabinet of Ministers, which regulated the matters of suspending payments on temporarily occupied territories, where such payments could be renewed provided the entitled individual moves to the controlled territory controlled by Ukrainian government. Again, this case was found inadmissible because the individuals did not use the individual claims. Instead, they made a collective application. And in those proceedings, their requirements were partially satisfied by domestic courts, while other portion of their demands was dismissed due to improper jurisdiction. And one more case from my presentation, which now is on communication stage. This is Shilina and others versus Ukraine, where the case is specifically about the IDPs entitled to pensions. And here the applicants claim that their property right was violated because they were deprived of pensions, and plus they claim that they are discriminated in view of special procedure to pay their pensions. The fact that they are supposed to be paid through so-called savings bank, they interpret it as act of discrimination. Now the parties have some time to submit the grounded arguments, and probably sometime in the nearest future, the judgments will be delivered in this case. Also, I'd like to mention the challenges that exist if we analyze the European court case law and the domestic case law, which was to some
І, відповідно, є і в аналізі, який підготував Верховний суд, ось і в цьому посібнику. Отже, я би хотіла зазначити, що до 2018 року існувала практика, була правова позиція Верховного суду України на той момент щодо отримувачів соціальних виплат, які проживають на тимчасово окупованій території. І, відповідно, позиція ця базувалася на тому, що особи, які не набули статусу внутрішньо переміщених осіб, не мають права на виплати. Ну, в цій справі мова йшла про регресні виплати, але разом з тим і щодо аналогічних спорів по інших видах, в тому числі пенсійних виплат, суди, коли ухвалювали рішення, вони керувалися ось цією правовою позицією. І до моменту, коли Верховним судом, Великою Палатою було здійснено відступ від цієї правової позиції, уже існувала певна кількість справ, які були, скажімо так, завершені, і рішення було остаточне, і воно було не на користь позивачів. Також хотіла би звернути увагу на відсутність механізму виконання рішень судів стосовно отримувачів виплат, які проживають на тимчасово окупованій території. І я зараз вже говорю не про негативну практику, а про ті рішення судів, в тому числі Верховного суду, які були прийняті на користь позивачів. Тобто стосовно саме ось осіб, які проживають на тимчасово окупованій території, і в силу фізичних особливостей, тобто це такий уже похилий вік, хронічні хвороби, інвалідність, вони не мають змоги не те, що здійснити переміщення, а навіть забезпечити, скажімо так, фізичну присутність на підконтрольній території впродовж навіть декількох днів. І також хотіла би зауважити в цьому контексті, що ось у рішенні у справі Кандиба проти України, власне кажучи, Європейський суд і наводить приклади успішної можливості захисту в національних судах прав ось таких жителів неконтрольованої території у національних судах. І дійсно так, і хотіла би що тут додати. Із ось 3 рішень, які наводяться у цій справі. 2 із справ ведення їх забезпечували мої колеги, адвокати благодійного фонду «Право на захист», і тому я дуже добре знаю подальшу долю ось цих рішень, тобто фактично виконати їх на даний момент неможливо, оскільки людина без фізичної присутності на контрольованій території, ну, принаймні не може відкрити рахунок у банку чи якимось іншим способом, щоб фізично забрати ось ті виплати, які, наприклад, якщо їй навіть виплатять. При цьому ми знаємо, що будь-які можливості, наприклад, нотаріальної довіреності і інші дії також недоступні. Тобто, в принципі, для жителів тимчасово окупованих територій, які мають ось фізичні такі обмеження в пересуванні, будь-яке виконання, воно неможливе. Також щодо виконання рішень судів, в принципі, ну, ми всі знаємо, що проблематика виконання
enforcement, execution of judgments. This is a well-known program. I shall not talk too much about that. I only want to draw your attention to the fact that apart from a general problem of non-execution of judgment, there are additional norms that make even less possible execution of judgments of court. I mean, a resolution of 647 of the government that refers to a specific procedure that will be elaborated and will regulate payment of indebtedness. Taking into account existing procedure, persons are refused to be paid pension, including even based on the judgment of the court. This is the problem of protection of rights of IDPs in the court. Coming back to the judgments in the case of Kandymov versus Ukraine, we did not study it in full, but there is such a problem. Legal uncertainty of execution of judgments of the court that recognize that particular legal acts are not effective. The resolution of Article 375, 378, there were many times appealed against in courts, and quite successfully. The court rules in favor of complainants. And certain provisions of these resolutions of government were ruled ineffective. However, one should mention that what was peculiar about the execution of these judgments of court, they could be executed pure technically. Execution based on ideology of the claim did not happen. As regards implementation of Resolution 519.5, the disputed norm was cancelled, but the new norm adopted practically was the same, only a few letters, a few conjunctions were changed, but the meaning was the same. Same happened with other regulatory acts that I mentioned previously. I would like to speak a little about novelties that were not included into this book, but probably will be of interest to participants. Lockdown limitations that are quite serious limitations for us all, but I would like to comment especially how it affects IDPs. especially those who live in the temporary occupied territories, this question of lockdown restraints and the issue of freedom of movement is much more serious for IDPs than for other citizens of Ukraine. In this particular case, these are the questions of ensuring balance between the public and individual interest when regulating border crossing procedure through checkpoints. Many of you read stories that people stayed for months at the checkpoints in the tents, staying for quite a long time in the buffer zone when some regulatory acts taken by a government were contradictory and there were some regulatory acts that were applied but were not publicized. That was the reason of very negative consequences for numerous people. Such cases are already pending in the first instance and appeal courts. And some preliminary judgments are made already. Other important issue, discretional use of administrative responsibility when crossing the border through a checkpoint. The amount of cash allowed to be carried from non-controlled territory. Now this procedure of crossing the border has very serious requirements, and people that got some pension payment for half a year or who go for medical treatment, they have the money above the established limit. In that case, administrative responsibility measure is applied. This money is confiscated. That limits possibility of people to exercise their rights. Lockdown limitations even make the situation worse. This is the issue that should be further discussed. It will affect the development of the case law. But I think we shall discuss it more later on. That is all that I wanted to say. There were some questions coming to me. I read some of them. The questions were of general nature regarding general protection of internally displaced persons, persons who reside in occupied territory. So I can confirm what the previous colleague said. You should act, you should address state authorities. And European Court of Human Rights says same thing. You should apply to the state authority, you must go to court. And if you have a lawyer, will make your case better. But of course, not every person have money to pay. But I must say that many organizations work pro bono and provide free legal aid. Therefore, observance of right for legal protection is possible.
So if we analyze the case law, In this connection, I would say that it certainly has a positive nature. I mean, the cases are considered in an expeditious manner in line with the recommendations of Council of Europe, and I think that's a special merit of project like this. Thank you. Thank you, Julia. Of course, our thanks to the judges and lawyers who have this common ground, common language. That's the basic, that's the most important part of this. And actually, this is what I emphasized from the first years of our existence, that our project is funded by the Office of Council of Europe to translate materials, to arm Ukrainian lawyers, judges with a proper document, proper approaches so that they can look for proper remedies even at the level of domestic courts without the need to go to European court. And our mission certainly is not to increase the number of applications submitted to the European court. I would also like to add that the publication authored or co-authored by Julia, who wrote bigger part of it with regard to the case law, domestic case law, will certainly be included into our materials in the respective convenient format. As far as questions are concerned, I can see that there are no more answers so far. I want to thank Julia for the comments, including the matter of protection of the rights of those who live on uncontrolled territories. Plus, we wanted to share some Georgian experience who are certainly moving forward and finding solution to the issue of identification of individuals who are deprived of any mobility, and they're looking for such opportunities to identify an individual by online instruments. A year ago, it seemed to be unique, but now it's not surprising when we move to this stage of our life. I thank you for the cooperation. I hope you'll stay with us till the end of the event, and certainly you will join us during the general discussion. Thank you. Now I want to pass the floor to Alla Fedorova, who will concentrate on the final presentation within our program, and the questions that were included in the questionnaire with regard to the needs of this event. There were questions about the property title, compensation, and access to the residential rights. Of course, partially, that's a matter for civil law institutions, and we understand that some of them might have been heard by another chamber of your court. But on the other hand, there are very important points related to protection of residential rights, property rights of the victims of the conflict. We asked Allah to prepare a short review of the judgments of European Court of Human Rights. Let's make it 20 minutes, not 30, to leave some time for summaries. And now you are invited to the floor with your final presentation from our experts. Good afternoon once again, and it is a big honor for me to take part in discussions around these problems. I need to say that initially this issue was not even raised, but then thanks to the first phase of the project which Hannah represents here, I can say that now in Ukrainian realities, these standards of European Court are clearly incorporated, because if you look at the case of the Supreme Court, including the cases presented in the short review, some of them were mentioned by the previous speaker. So in each judgment, we can see reference to the standards and judgments of European Court of Human Rights, meaning that as of today, when we look at judgments and determinations, not only of the Supreme Court, but also other courts, we will see references to the standards of the European Court, and including the judgments that have been translated into Ukrainian by the project of the Council of Europe. So let me push my presentation on. I hope I can make it quickly. So indeed, if we are talking about the case law of European Court on Human Rights in connection with the armed conflict, yes, there are different aspects of it, and many of them have been covered by the European Court, including compensation for the lost property, matters of social entitlements, pensions, etc. Talking about social issues, very briefly, I would say that European Court applies not only Article 1 of Protocol 1, but also that's Article 6, the right to fair trial. They are often referred in combination, but also Article 8, 2, even Article 3, where some individuals are trying to invoke Article 3 when protecting their rights. But I'd like to mention that the social rights or IDP rights are not mentioned by the convention. So this principle of non-discrimination of IDPs, which actually is part of the guidelines of the United Nations with regard to IDPs, means that any support to the population should be provided, including the support to IDPs without any discrimination or exceptions. Social assistance and pensions, according to under Article 1, Protocol 1, the European Court has had a number of cases like this. I think the judges already know that the social and pension issues of IDPs have not been often cases in the European Court, but the whole case law of the European Court on social matters and pension matters are applicable to IDPs too. We can mention this practice case law starting from 1979, the case of Airy versus Ireland, and going further on with Hanyakina versus Georgia, including the famous case Pichkur versus Ukraine, because now most of the references are made to this specific case, Pichkur versus Ukraine. Let me briefly talk about some legal positions about the system of social subsistence as worded out by the European Court in the context of their judgments, which certainly includes the rights of ADPs. The state may, at its own discretion, decide on the payments to be made available within the social security framework, the sources of such payments, state budget, foundations, etc. This is the freedom of government's discretion, which is left, this margin of discretion left by the court to the state. But if there is some legislation in place which certainly provides for social guarantees and an individual is entitled to such payments, then an argument like a lack of funds in the state budget will not be acceptable as justification not to pay. The European Court stated that several times. I think it also makes sense with regard to the right to pension for the individuals who were either entitled to pension but didn't receive it, or who were entitled and received the pension. They can never be deprived of their right to pension, and the rights of applicant to the pension has never been questioned by the court. Well, the discussions were about some reduction of amounts. There were different options of the judgments delivered by the court. It's emphasized the non-discriminatory nature of such reduction, etc. But actually, let me talk just about two judgments with regard to the pensions for IDPs. And these judgments are applied by Ukrainian judges, but as we can see from the case law, maybe to a smaller extent comparing to the judgments of Pichkura case. So the case Grudic versus Serbia as of April 2012, it was about granting a disability pension to two Serbs of Bosnian origin. It was granted by Kosovo Department of the Serbian Pension Fund. Then they suspended these payments, and the justification was the Kosovo is under international administration, so no further disbursements are possible. The Serbian government explained, we can even hear it from some Ukrainian authorities, that the payment system of Serbia pension system is pay as you go, when the working people earn pensions for the pensioners. So if Serbia cannot collect these contributions in Kosovo, it is not supposed to pay the pension to these pensioners. So European Court did not accept such arguments, and it held that deprivation of an older individual of pension cannot be justified by any social interest or any public interest. So suspension of disbursements of pensions to individuals on the territory controlled by international administration was not found as a justification for violating their right to pension. The same position was taken by the court in the case Pešić versus Serbia. In addition, there were some other judgments of similar nature against Bosnia and Herzegovina, Croatia, Slovenia, etc. So this case law with regard to Balkan countries is less known in Ukraine. That's why probably Ukrainian courts do not use it often. But let me mention the judgments of Administrative Court of Kiev, where the matter was about an individual who used to live in a non-controlled territory, and they moved to Kiev, and here the Kiev court referred to these two cases that I showed in the previous slides. I won't talk about this case, Caesar versus Ukraine, because it has already been mentioned and discussed. And actually, the European Court stated that there is a difference between the situation situations of those who are on uncontrolled territories and controlled territories, whether the former can have an opportunity to visit the controlled territory. So again, it makes the status of this individual different. Talking about the case of Kandiba, which was actually delivered, the judgment was delivered just several weeks ago. It was 13th October. But anyway, here we should not say that the European Court stated that Ukraine is not supposed to disburse pensions to the citizens because there are publications already, as you know, about the mass media rights, that's a victory of Ukraine, like allegedly those who are on uncontrolled territory should forget about their pensions. That's not true. The court didn't state that. The court just stated about the possibility to renew some disbursements after suspension. Now compensation of the housing, for the housing. Here different principles can apply, including powers and principles. There were various documents of Council of Europe adopted in this context. Consistent in the fact that once displaced, the individuals are not deprived of their property title, and they should exercise their right in order for this property to be restituted or duly compensated. Let me draw your attention to the fact that the European Court of Human Rights interprets the right to housing as many other rights in its autonomous meaning. It's not necessarily about a house or apartment which was destroyed, had to be owned by the individual. So European Court in the case Lagarde versus Turkey mentions some evidence that can be submitted to prove the property title. So some basic judgments for the matters of housing of the ADPs. Of course, that's the case with Zida versus Turkey. That's the basic classical case, which is well known, I think, in Ukraine, including the judges. Cyprus versus Turkey, Dragan and others versus Turkey. The two cases, Saginadze, Gulbamadova versus Azerbaijan, that's a different matter. At stake is when an individual, an IDP, lives in a temporary location granted for temporary residence. The government is not allowed to just deprive an individual from such housing. In the case of Georgia, it was stated that this housing was granted to an individual because of her office, because of her work. But when she stopped working there, she was asked to leave the place. In Azerbaijan case, that was a question about the balance between the title to a house, say an apartment, and then this apartment was granted to another person. So here there is an obligation of the state to undertake some housing programs within the reasonable term of time. But on the other hand, there should be fair balance between the individuals entitled to housing who are not IDPs, but on the other hand, the right to housing should be also guaranteed and exercised by IDP. There are some other cases I forgot about, switching the slides.
What is important in all those cases concerning compensation for destroyed or damaged housing, They're numerous, and European Court in all those cases demands from the state to create effective mechanism of compensation. In a regular case regarding compensation, not only for destroyed or damaged housing, but even having no access to your housing for a certain time was seen by the court as violation of Part 1 of Protocol 1. The court ruled that it should be necessarily created availability of effective legal remedy for all those persons, not only those who apply to European Court, but all those who are covered by this concept and are entitled for that. This judgment was confirmed by European Court in other case, Demopoulos and others against Turkey. And the court ruled that if such mechanism is provided, then first of all, you should apply it. In case Chiragi versus Armenia, Sargsyan protest Azerbaijan, the court ruled that the state must create similar remedies at domestic level that applicants do not go to European Court. As regards Ukraine, we have one or maybe two decisions about admissibility were taken, Lisny versus Ukraine and Philomenko and others versus Ukraine. When applicants try to prove that they have the right to get compensation for destroyed housing, but they didn't provide any evidence to European Court. Only copies are of their passport. And European Court said that it's difficult to collect documents and evidence in such case, but there should be at least tried. That should be a copy of your ownership certificate or photographs or pictures or testimony of the witnesses. Up to now, there is no judgment of European Court regarding pension to IDPs, and we don't have the judgment regarding compensation for ruined or damaged housing, including housing destroyed or damaged on the territory which is not controlled by Ukraine. Anyway, what we have now, which is the confirmation of the fact that lawyers are hurrying up to file application to European Court, non-exhausting all domestic remedies. I try to fit in the time allocated to me. If there is a possibility, I will answer questions. One last comment. New decision of Kambeda versus Ukraine. There is no official translation yet, and there is an article published in Юридична Україна newspaper. Colleagues of Yulia, lawyer Tarasenko, made analysis of this judgment of European Court in Kandeba case. Thank you very much. We'll be pleased to answer your questions, if any.
Шановна пані Алло, ми вам надзвичайно
Dear Allah, we are very thankful to you. We realized that you had quite a lot of information and you had to do it at a time when everybody is tired. And it's difficult to work online, it's difficult to listen online, it's more difficult to make presentation online. We are very thankful to you for giving us a comprehensive picture. But again, I want to emphasize that in the materials that you will get from our webinar, there will be a separate publication of Kostas Paraskeva with the analysis of case law of European Court of Human Rights connected with internal displacement. But in the case law of domestic case law presented by Julia Trala, there will be some excerpts of classical judgments of European Court of Human Rights in connection with the conflict, internal displacement, in particular case Cyprus versus Turkey, where there are very significant positions of the court regarding legal documents in the sphere of private law, private status, private title issued by authorities that originate legal consequences for persons who live on de facto territory. On the one hand. On the other hand, they are not recognized by official authorities of the countries whose territories are occupied. Namibian exception was mentioned there already, but consideration of the court regarding Namibian exception of European Court of Human Rights that they suggest in this case, Cyprus against Turkey, are very useful. And it would be very important for all of us to come back to that when preparing legal field for reintegration of temporary occupied territory. Because general approach that the court defends, one should not intertwine or confuse issues of human rights of persons who are forced to stay at the temporary occupied territory. Their rights could not be completely ignored. But because of international legal status, these documents are not recognized by state de facto. There should be a kind of balance between the two. And the rights of a person should be taken into account. And the documents of civil status, birth certificate, marriage certificate, labor book that confirms number of years that a person has worked, and confirmation of certain facts of legal nature, and even decision regarding place of residence of the child. They must not be automatically recognized as null and void. And documents must be taken into account to some extent by state authorities. Of course, this is a difficult issue, but one should talk about that, must think about that, especially at the stage that we all hope that temporary occupied territories will be reintegrated. European case law will be presented to you in detail in our proceedings. You know this case law very well, and you use these materials quite actively. And monitoring that we conducted 2 times in our project, that cases regarding conflict and displacement are used in more than 60% of cases, although the actual result cases are not less than 6-7%. So you can see that thanks to you, thanks to the fact that you use standards of Council of Europe, you are developing national legal framework for protection of IDPs. I used my time for the closing remarks to make this comment. We are thankful to our partners. We are thankful to Cassation Administrative Court for our really wonderful cooperation in preparation to this event, in disseminating and sharing materials, in promoting standards of Council of Europe. We are thankful to National School of Judges, which is our very important partner, and we hope all that project has developed at this stage of implementation will serve to interest of Ukraine and interest of persons whose rights should be protected. Since I don't see new questions and answers in the chat, I have used my final remarks word. Therefore, I invite Susanna Mnatsakanyan, who is Senior Project Officer, for her final word and presentation of future program on social charter. And then final comments, conclusions, and recommendations will be made by Steve Mikhailos Smokovich. So, Susanna, the floor is yours. Thank you very much, Hannah. It was a really difficult day, but let us hope that it was an effective and useful day. I am trying to make my screen broader to show you slides regarding the next program that we are preparing. Sorry for that, I can't do it. I cannot show you slides, so I shall just tell it. So we have prepared for you, I mean for us, all of us, all legal professionals who are concerned with protection of social rights. We have conducted a study in our project that showed when we asked the question to judges, which international documents you use in your professional activity, 93% of judges said European Convention of Human Rights, and only 15% mentioned European Social Charter. Although we understand very well that social rights are not the questions that are not within the jurisdiction of courts whose judges we applied. We asked them about their category cases that they review. So for sure, the European Charter should be an instrument used. When we asked directly, do you use provision of social charter? 80% said that they don't. 68% said that they do not know about case law of European Committee of Social Rights. We cannot say that this is good or bad. This is just a fact. Activity of European Committee of Social Rights is very different from activity of European Court of Human Rights. But their judgments, by their format and by mandatory implementation are same important. But interpretations that European Social Rights Committee makes could be of great use to judges. When we ask judges who took part in the survey, do you want to know more about provisions European Social Charter? 93% said yes. Therefore, we think we are on the right way, and therefore the program that I will present now will be useful and effective. Based on the study conducted, we got to know that the most desirable form of getting information about social rights of charter and activity of committee would be training, continuous training in the National School of Judges. 65% of judges said that. 45% of others wanted to get information materials, booklets, and manuals. Therefore, when developing our training program that we are doing. And we expect that by the end of this year, this training program will be finalized. And from early next year, we can start trainings already. There will be two formats. Both the manual, the guide will be issued, and training will be conducted. So it is focused at provisions, European Social Charter, conclusions of European Social Rights Committee, and application of Social Charter by domestic court. First, introduction of European Social Charter. We provide general characteristics of the monitoring body and use of European Social Charter in the context of Ukrainian legislation. Second part, devoted to particular rights guaranteed by the Charter. Together with our experts engaged in this process, both international and national, we were discussing the rights for almost 1 month, which of them to choose. That will be covered in most detail. Depending on types of cases that are reviewed by courts, we discussed it with judges, with the national school. Out of 31 rights guaranteed by Social Charter, we had to select those that will be covered in detail in order the judges can refer to conclusions of Committee of Social Rights or to some provisions of the Charter that will help in their motivation part. But we couldn't manage to find the most important one. Therefore, we decided to cover them all, apart from those that Ukraine had not accepted. So, based on the result of our activity, we shall get a manual and a training program that will start next year that will have characteristics of all rights guaranteed by Social Charter with description and references to the conclusions of European Committee of Social Rights that could be of use for all judges when motivating their judgments. Of course, we shall work as much as possible with judges, with the National School of Judges and High Administrative Court, at Supreme Court, to make this training program as adapted to the need of judges as possible, taking into account limitations of the COVID-19 lockdown and big workload of judges. We shall compile a time schedule suitable for judges. We shall divide this training into particular sessions. Judge will be collected in groups, so you will get all the instruments for application of the Charter. Now you don't have all translations. This case law is not well known, but we are working on that. In the course of our project, we not only focus attention at providing this instrument to judges, we also work with the lawyers. We are developing the training course for lawyers and for law students in order that new generation of lawyers, future lawyers, will apply Social Charter from the very beginning of professional activity. So we hope to ensure application of European Social Charter and case law of committee at the same level as European Convention of Human Rights and case law of European Court for last 10 years. Thank you very much for your participation for this webinar. Very good synergy with all partners, and we thank High Cassation Administrative Court at Supreme Court for this initiative, for their support. Thank you really very much. We are very glad to join words of gratitude from our side. And now I give the microphone for final summary and final word to Mr. Mikhailos Smokovich, Head of Cassation Administrative Court within Supreme Court.
Дуже вам дякую.
Yes, thank you very much for offering the floor. First of all, I want to thank our partners for their support, for organization, hosting of this webinar on protection of social rights of IDPs and of other vulnerable groups, according to European Social Charter. And with consideration of the case law of domestic courts in Ukraine, my thanks to the office of the Council of Europe, to the respective project of the Council of Europe, represented here by Ghana Christova and Susanna Nazaganyana. I'm really thankful to you for organizing this feast. Indeed, without any exaggeration, I'd like to say that I'm really touched with the completeness of information and of the topics that we have been dealing with during this webinar. Indeed, today we heard many new things. We heard about the work of European Committee on Social Rights. We heard about how we can use their decisions in our case law. We Ala, who is a real fan of this area, literally digested this information for us on how you can interpret all that in Ukraine. And we understand how important this charter is. We did have this understanding before, but now we even better understand the importance of this charter for purposes of resolution of these disputes. It's clear that as of today, the social protection of these individuals is probably the most important aspect of their life, because that's about protecting their health and life. So I want to thank the administrative judges and especially justices of the social chamber of the Supreme Court, who carries this burden of protecting the basic fundamental rights of these individuals. I just bent down in front of them. And what we heard today certainly will be further used, and it will make the protection even more efficient, more dynamic, more in compliance with the international standards, although the Charter has not been ratified by Ukraine in full. Also, we heard a lot of information on other countries when we heard from the representative of Moldova, Lilian Apostle. So, indeed, you may be really surprised by the fact that in century 21, at this level of civilization, European countries go through such hard times, and not the poorest countries, very well developed countries. But certainly the court's mission is to defend these people, and we certainly like your approach to further development of this subject matter, adding some training format to it. It's very important that you conduct such classes for students, for lawyers, but I would say that to add even more efficiency, it would be good to train public officials of maybe governmental authorities or local government authorities. They certainly need such training badly. And we, as administrative court, will train them through our judgments. But on the other hand, as we usually do, jointly with a similar project, we will teach them how to defend the freedoms, how to defend constitutional, conventional, charter rights and freedoms of individuals. So I think it would be very good and efficient idea for that purpose. You can certainly invite the justices from Cassation Administrative Court to deliver this message, to the heads of our public authorities, because yes, we deliver judgment, but they have to execute. It's great to hear the chair of the European Committee for Social Rights. For us, it's a very important fact to be reminded that such committee exists. And that we apply its decisions. So you've also demonstrated that the European Convention on Human Rights is something really universal. But here we are dealing with a level of protection of human freedoms as special subject matter. I need to say that in December of the current year, the Convention on Access to Governmental Documents ratified by Ukraine will take effect in Ukraine. That's an important addition to the protection of fundamental freedoms of the people. This is the way for Ukraine to enrich its national legislation and the way for Ukraine to become even closer to European and international levels. So again, sincere thanks to everybody, to the trainers for speeches. More thanks to Justices of Cassation Administrative Court who reported on the case law. And it's very positive, this is the fact that the courts do apply the charter when considering such disputes. I want to thank all participants of this event. I've certainly been watching, monitoring the number. We've had more than 100 continuously here, which clearly shows the high interest of this topic. And of course, the judges have received very serious assistance for purposes of consideration of such cases. So thank you very much again for your cooperation, even within some specific format. If you consider some assistance, methodological assistance to the lawyers, to public officials, we will be ready to support you. Because, when an individual sees a judge, maybe his word may have a bit more weight than anybody else's. So thank you very much for helping Ukraine to achieve, to really reach this European level. Thank you. Thanks a lot. Thank you. And indeed, you have drawn a line and we have nothing to add. We keep in touch with you. We'll do our best to help you, to assist you. This event was organized by the Supreme Court with the support of two projects. The projects on development of social rights of an individual as a key the factor of consolidation of democracy in Ukraine, and the project dealing with the internal displacement. So thank you very much. Yes, Hannah, on behalf of the National School, I'd like to say that I've been with you all this time, and I could hear everything that was mentioned with regard to the role of the National School, since it's only now when I have an opportunity to say a few words. It's not. I clearly heard the real missions that should be imposed on the National School of Judges. The task for Cassation Administrative Court. So I want to thank all participants for their suggestions, and certainly we'll get in touch again and we'll work together. Thank you for this intervention as guidelines for our further steps and active events and activities. Thank you all. Have a good night and strong health. All the best to you. Will stay in touch.